What's that? We're going to start. Do you you know how to work your mic? Yeah, just press it. Red light goes on, you're on. Okay, folks, we're going to start our meeting here in a few seconds. Mr. Webmaster, are we now live, connected, and streaming? Okay, folks, good morning. My name is Randy Miller, and I am the chair of the Malpractice Insurance Working Group. I, of course, want to start by welcoming all of our working group members here. Thank you for all of your hard work at all of our meetings this year. There was a lot of work and effort that went into putting this meeting together, and we're going to hear a lot from Glenn and Mark today about all that they've done to put this together, which includes a number of really interesting and helpful speakers. I want to thank our speakers. I know that a couple of them are here already, and we thank you for making the trip to Los Angeles, perhaps out of the smoke and into the smog. And so thank you for being part of our group here today. I also want to acknowledge that we may have others that will be attending our meeting today. We welcome you. Thank you for coming and having an interest in these topics. We look forward to your comments, and I'll address the time slot for public comments in a few minutes. As we know and are used to in our working group, these sessions are all streamed live by webcast, so I welcome our webcast attendees. Hopefully you can follow very clearly what is going on here today. It's obviously done in video, it's done audibly, and it's also transcribed. We have an agenda posted on the webcast, and every of the study group members has a copy of the agenda here. It is my intent to follow that as closely as possible today, not only to keep things moving through today's topics, but also that those attending here and also by webcast can follow everything that we're discussing live. Just real quickly, for those of you that are speaking or addressing anything here today, I want to make sure that you know to turn your microphone on, turn it off if you're not speaking, and just make sure that you speak audibly and clearly so that it can be picked up in the webcast and can be transcribed accurately. And in terms of our program today, we do have a very, very tight schedule. We posted the agenda online. Today, the topic will be headed by our subcommittee, Captive Insurance. This is a very, very important topic to this study group. It is a very important topic to the members of the bar and to the members of the public. So we welcome a full and faithful and exuberant discussion about this topic here today, as we've had with all of our topics. And just in terms of where we are in the arc of this, you know that we've now, after today, will have addressed each of the topics assigned to the subcommittees here that correspond with the questions that the legislature had asked the Board of Trustees and us to research. We'll probably talk more at the end of today's meeting in terms of where we go from here, in terms of processing this information, assessing the information, and determining how or the structure of our analysis and perhaps some recommendations that we'll make as part of our study. And so that is right around the corner. I would say we're probably in the seventh or the eighth inning of this game, and we need to continue to move through everything that we're dealing with here efficiently so we can provide to the Board of Trustees our analysis and recommendations. And the Board of Trustees, as you know, has to provide their ultimate recommendations to the legislature by March 31st, 2019. So we're on track. Thank you very much for all the work that you've done. In terms of the public comment, I know we do have members of the public here today and other licensees, lawyers. I want to give you an opportunity to address the working group. That will probably take place around 1:50 or 2 p.m. this afternoon. We have a very tight agenda between now and then, but I do want to give everybody the opportunity. Depending on how many people that we have that want to make a public comment, we may have to limit that to some degree. And so we can move through the rest of our agenda carefully and complete the day. As always, we have been very busy between the last meeting and today. I know that a lot of you follow this very closely. We've posted all of our materials online so that everybody here in the working group and licensees and members of the public can look at it, all the materials that we've assessed. We've gotten a long list of very important comments that were provided to Linda and the State Bar over the last few weeks. And we have collected all those. They are also posted online. Linda Katz did a summary of those, which is also part of that collection of materials. And I think there's a few copies floating around here today. So if you haven't looked at those yet, I encourage you to look at those because it is very, very helpful. Many comments from many sectors out there that bear directly on the issues that we're considering. So I encourage you to look at those. In terms of today's agenda, I'm going to turn it over to Glenn Olson and Mark Abelson in a minute. They are chairs of the subcommittee that studied the captive insurance program. They've constructed an agenda today that is extremely comprehensive. So again, I want to thank them for their work and diligence in processing these materials. This is a dense topic, and I want to make sure that they have full opportunity to present every aspect of it. So Glenn or Mark, if I can turn it over to you, I'll have you take it from here, introduce your speakers, and tell us a little bit about how the day is going to go.
Thank you, Randy. Just to set the stage, we're the part of a subcommittee that was to address the captive insurance issue, and it's part of a kind of a larger group with Scott Barabish, Heather Rosing, and Connie Broussard that addressed a number of different topics, both mandating insurance in the open market, which is what we addressed at our last subcommittee meeting, and also what it would mean to mandate insurance and run it through a captive insurer. So that's the piece of the program that Mark and I have been asked to address, and we put together a panel of speakers today to address it. Just to set the stage, there aren't a lot of, in the United States, examples of captive programs that run mandatory malpractice insurance. In fact, it's limited to Oregon in a captive program. We've been blessed to have Carol Bernick of the Oregon PLF, Professional Liability Fund, here to speak to us today about the Oregon program. And in the afternoon, we've got Dan Pennington, who is the CEO of LawPro in Toronto, Ontario, the head of that program. So he'll be on videotape to address some of the issues relevant to the challenges that Ontario faces. It's an interesting topic, and when Mark and I started looking at this, We're looking at captive insurance in the context of what appears to be a pretty robust open market system in California. We have a number of insurers that write insurance. We've addressed it in our various meetings that there's a lot of different carriers in the market, from Kathy Sargent's company, LMIC, to a number of different commercial insurers and a state-sponsored program in California written by Arch. So we're looking at this in a different way maybe than programs have looked at this in the past. It could very well be that you'll hear today that some of the programs that have been run as captives were initiated in the context of a hard market, where insurance was either extremely limited in accessibility for lawyers or extremely expensive. So we're kind of going at it from a different angle, but as Randy said, I think the issues are very, very important, because I think there's a lot of lessons that we'll be able to learn and issues that we can address as to what captive programs see. It's an interesting, really an interesting vehicle by which to issue mandatory malpractice insurance, in the sense that you corner the market when you have a captive program. You really see the entirety of the populace of the insured lawyers, at least at the primary level. So there may be some really good lessons there that we can learn, and issues that we can address. We're going to ask the speakers today to talk about how their programs began, really what the drivers were, why consider this type of program, why consider this rather than something else, how the programs operate. Do they, how do the programs operate in the sense of claims frequency and other statistics? How is that studied? How does that feed back in a loop to risk management? And what interaction exists between these captive programs and other parts of the legal community, including the bar and members of the public and other interest groups and stakeholders? So all of those, I think, are very interesting issues. In the afternoon, we're going to shift gears a little bit and talk more about the mechanics of captive insurance. We have Courtney Claflin here, who is a head of captive insurance for the University of California, who set up a number of different captive programs to address everything from medical malpractice to property and casualty insurance for the university system more generally. So the idea there is to use that time to ask the questions we need to ask about how do you start a captive, what does a captive look like, how is a captive managed once it's up and running. So those are issues that we will address with Courtney. And then last but not least, this morning we have Professor Hugh Spitzer, who was the chair of Washington's essentially a committee that's analogous to the one that we're on, their working group about mandatory malpractice insurance. And he's going to talk a little bit about these issues, having looked at and admired, I believe, the Oregon program and the conclusions that Washington, came to based upon their fairly robust open market and the different options that they faced in terms of their recommendations. So it's really an honor to have Professor Spitzer address those issues as well. So it is, as Randy said, a fairly ambitious day, but one of the things I would like to encourage folks to do is we have some great speakers here today, and I really would encourage you to ask questions of them as to how their programs operate and maybe what teachings come out of their programs that might be applicable to the work that we're doing here in the Malpractice Insurance Working Group. So with that, the first of our speakers is Carol Bernick, who is the CEO of the Oregon Professional Liability Fund. And thank you so much, Carol, for being here to talk to us. Carol was previously a trial lawyer and partner with Davis Wright Tremaine in Oregon, I imagine,
Yes,
in
indeed.
Portland.
Yep.
And has been with the Oregon PLF since, I believe, 2014.
Right.
Is that right?
Just past my 4-year anniversary.
It's great to have her here, and I thought maybe, Carol, we could kick it off by you describing your program and how it got underway and
Sure.
what some of those drivers were.
Sure. Hopefully in your packet of materials, you got a handout that I provided, which is, I called the Oregon PLF by the numbers. And I'm not going to go through all of those, but that could be a reference for you. And we are also a public entity, and so much of what I'll be talking about is on our website and available for public consumption. So if there's anything I talk about that you want more information on, you're welcome to go to the website. You're obviously welcome to call me. But thank you for having me. I was given a list of questions to talk about, and I will try and touch on all of those following the sequence that Glenn just described. But I want to obviously make sure that I answer whatever questions you might have. Okay. We are 40 years old. We just celebrated our 40th anniversary. We were begun in a very hard insurance market. Lawyers in Oregon could not get insurance, particularly small and solo lawyers, those who wanted to get insurance. It was either unavailable, literally unavailable, or it was very expensive. So one of the questions I've been asked both by this committee as well as other committees like Washington and Nevada and others, did we consider another option like mandatory disclosure? Well, that really wasn't available to the bar at the time because, there was not a question of disclosing you didn't have insurance when you were trying to get insurance. The one thing that many other states did at the time was to create bar-related insurance companies, and thus was born the NABRICO organization, the National Association of Bar-Related Insurance Companies, of which the PLF is a member, as is Kathleen's organization, is also a member. And that was the solution that a lot of other states came up with. It wasn't a mandatory program, and it wasn't a captive program, but it was a program that was designed to be a vehicle to get insurance, affordable insurance to lawyers, particularly small and solo folks. We are mandatory and we are exclusive. So if you are a lawyer in private practice whose principal office is in Oregon, you must buy your first $300,000 of coverage from the PLF. So as I say to people, we have a very small marketing department, right? Not only do you have to have it, you have to buy it from me. So, but it is also exclusive in the sense that if you are an Oregon licensee whose principal office is not in Oregon, you may not purchase PLF insurance. It is a shared risk pool, which means that we have a one price for everybody. Currently, it is $3,300 a year, effective January 1st. We lowered what we call our assessment by $200 this last year, and so it will go into effect January 1st. You will hear me use terms that are not typical terms used in the insurance industry, and the reason for that is because the Oregon State Bar Professional Liability Fund was by statute exempted from the insurance code at the formation of the organization. So we try and stay away from insurance terms to keep everyone reminded of that fact. We have an assessment, not a premium. We have covered parties, not insureds. So I will try and I just give you that. I should give them a glossary in addition to the other things I've provided. But that exemption from the insurance code was important because of the added costs that are associated with being regulated by the insurance code in terms of your capitalization, as your rate filings, all that kind of thing that we don't have to do. Because we take everybody, and yes, in answer to the anticipated question, if there is a lawyer with 25 claims, he continues to be insured by us. We do take everybody and we charge everyone the same price. I think the thinking was that it wasn't necessary to have us be regulated because the things that the regulations do to protect the consumer of insurance products are not present for us because of the way we do our business. Our current limits, as I said, is $300,000 per claim or in the aggregate. Every claim also has a $50,000 claims allowance. That $50,000 allowance, expense allowance, that $50,000 cannot be used towards indemnity. So the most that can be used towards indemnity is $300,000, but it is a burning policy. So if the $50,000 expense allowance is exhausted, then the indemnity limits start to burn. So one of the questions that is frequently asked, and I'm just going to get my worksheet up here of the questions that that you had. One of the questions that's frequently asked is how did we capitalize at the beginning? So what happened was there was a working group about what to do about the absence of insurance in Oregon in the early 70s. And what the statute that was ultimately introduced said was that it authorized the Oregon State Bar to create a fund. And that fund could create a plan or a policy with its own definitions in terms of coverage and the like. And that any such fund so created would be exempt from the insurance code. So that's about the sum total of the statute. That's what the Oregon State Bar did, create the fund. We charged $500 for $100,000 of coverage in the first year, first 2 years. And that was our capitalization. I mean, that is, we didn't, the bar subsidized the hiring of a CEO who at the time actually was the insurance commissioner of the state of Oregon, who came in to be the CEO. And that lasted for a couple of years. But beyond that, it was a pay-as-you-go kind of thing. In the early 90s, we began to really push hard to have sufficient reserves and capital to be able to have more protection from, I mean, literally we would have lawyers on our defense panel who we would say, submit your bill in January because we don't got any more money in our coffers in December to pay your bill. So we wanted to get away from that and be fully reserved. And we are, and have been since the 90s, fully reserved. One of the things that I hear a lot is, the other thing, who was for it, who was against it. I was not there at the time, and we don't have, terrific records of the pros and cons at the time. But in many ways, solo lawyers were actually far more for it than I think solo lawyers often are in the discussions that are happening California, Washington, Nevada, because again, those were the folks that couldn't get the insurance that wanted it. It was also a very different time. I think lawyers in 40 years ago, what I say to people all the time is, I think if you tried to do this in Oregon today, I think there would be mass revolt. But if you tried to take this away today, there would be mass revolt. It is part of our culture now. It is 40 years. There's very few lawyers who are practicing, who remember practicing in Oregon without the PLF. I tell people in Oregon, and I was one of them, having grown up in Oregon, not as a person, but as a lawyer, I had no idea that malpractice insurance wasn't mandated in other states. And 90% of the lawyers I talk to in Oregon are shocked to hear not only that we're the only state, or now Idaho as well, that requires lawyers to have malpractice insurance, but that we have this mandatory captive fund that no other state has. They just assume everybody else has it and does it. So it is definitely a part of the culture there, and I think it is well regarded part of the culture for a couple of reasons. One is we have very high quality and very active claims attorneys who work on any claims. So almost all of the claims attorneys had been partners at law firms before they came and joined the bar. They had been trial lawyers. They were very experienced malpractice practitioners, and they take a very active role in the cases, whether they're cases that we handle internally. We don't handle anything that's litigation internally, But if a claim is made before there's litigation, we may try and either resolve it or deny it or whatever it is. But even when there's outside counsel, and we do surveys of our covered parties at the conclusion of any claim and ask if they were satisfied with the services not only of the claims attorney, but outside counsel. And we have 100% over the last 30 years of people, 99%, let's be honest, 99% who say they are either satisfied or very satisfied with the services of the claims attorneys. And, you know, we have 7,200 lawyers who are covered parties, and that makes a big difference, I think. The other thing that we do is we have a very robust loss prevention program. 25% of our operating budget is loss prevention. We have the lawyer assistance program as part of the professional liability fund. That's 4 attorney counselors that are part of the professional liability fund. And then we have 4 what we call practice management advisors. These are people that if you are going to start your own law firm, they will come out to your law firm and they will help you figure out whether or not you've got the right conflict system, the right trust accounting work, the right docketing system. They will help you with document management programs. They will recommend different things to you. We go in when somebody gets ill or, you know, has an accident. You know, these solo lawyers who you know, are in a coma because they were in a skiing accident and don't have an assistant, don't have anything. We will go in there and get your practice protected, get the cases farmed out to other lawyers to handle temporarily while you are recovering. You know, in today's day and age, we are getting increasing issues with older lawyers who have not let go of their practice for whatever reason, sometimes by necessity, sometimes by ego, sometimes, you know, all sorts of reasons. And, you know, they die suddenly or their dementia becomes so significant that they are unable to practice. We will go in there and handle those situations and help protect those lawyers. It's both an ethics sort of protection. I mean, we help with issues of shredding documents and that kind of thing, which isn't typically a malpractice issue. But we also obviously are very focused on the malpractice prevention. We create 400 practice aids that are free to lawyers. We do 30 CLEs a year, which are free to lawyers. We develop all sorts of handbooks. We have a statute of limitations handbook that is literally 1.5 inches thick that is free to lawyers. So there's lots of resources that we devote. And again, I think that's part of what makes our credibility with a mandatory captive program contributes significantly to that. Another question that I get asked a lot is about the frequency. Isn't mandatory malpractice going to cause claim frequency to increase? And I think the answer to that is yes. Our frequency is somewhere in the neighborhood of about 11 and 11.5%. So 11 lawyers out of 100 are going to get a claim in any given year. You compare that to any other private insurer and they'll say it's 2.5%, 3%. Kathleen, I don't know if that's probably, I don't know if you share that information, but, you know, certainly that is typically what we hear from other private insurers. And there's a couple of reasons for that I could say that would bring that 11% down to maybe 8%, 7%. You know, we hand out claim numbers like candy, right? Because there's no downside to you in having a claim. Your premium isn't going to go up. We do no underwriting. Everybody pays the same amount. You're definitely going to be insured. We have a very strong culture of call us. And we get calls from people who want to know whether the statute of limitations on this particular claim is X or Y. I mean, we do not assign a claim number to that. We also tell them we are not your associates, and so you're actually going to have to do your own legal research. But we get a lot of calls when people are just uncertain about something. They think they may have a conflict. Their client has accused them that they have a conflict, whatever it is. And, you know, sometimes if we think there is a possibility of a claim there, we will often assign a claim number. And so we're probably more generous than the commercial market in assigning claim numbers. We also provide, if you get your client wants his file or its file, or wants to take your deposition, former client, current client, the divorce that you handled 5 years ago, there's now a change in circumstances being filed. You're no longer representing the client, but the client wants your file or wants your deposition because that's relevant to the issue of the change in circumstances in the custody or asset division or whatever it is. So no claim, but because we hire a lawyer to defend you and to look through your file and help you make sure you're producing what you're supposed to produce, we count that as a claim file. We do a lot of repairs, and that's also a claim file, claim number. So if you take all of that into consideration, that would lower that frequency down to some number. I don't know what it would be, 9-8%. It's still going to be higher. You are going to get more claims. But there is at least some anecdotal evidence, and I think it's impossible to have empirical evidence that there are people out there with viable claims, legitimate claims, who do not bring them in states or places where the lawyer does not have insurance. Again, there's articles that have been published recently. There was a book published by a professor from Minnesota, Bert Kaiser, that just came out about lawyer malpractice. Linda Lavin did an article in the Florida Bar Journal that you've probably seen, Lawyers Going Bare. And again, it's hard to quantify that, but I think there is evidence of that. One of the things that I provided in the materials I sent you was, the number of claims that we settle without paying anything. So the disposition of claims, this is in the last 5 years, 23% of our claims we paid neither indemnity or expense. 45% we paid expense only, so we hired outside counsel. Sometimes that's just a review to help us figure out what this bankruptcy issue is or whatever it is. 14% we paid indemnity only. The claim came in, it was a claimant and or her counsel were able to sufficiently establish the elements of the malpractice claim for us, and we settled it and we paid it, right? And for 18% we paid both indemnity and expense. We are $1 coverage. There is no deductible. So, that's again another reason why our claim count is higher, because as soon as somebody gets a demand, oftentimes I imagine with Kathleen's company, the lawyer tries to handle it themselves. I'll give you your money back, or I won't send you the bill. Can we drop this? Can we resolve it? And they never hear about it. It gets settled themselves, or they have a $5,000 deductible and the demand is $3,000, and so they don't report it. That's not the case for us, and so we do handle things right from the beginning, and so we do have high percentage of reporting from our covered parties. Just interesting, some information about how we dispose of claims. 30% of the claims are settled. 28% of the claims are abandoned, 18% are repaired, 14%.
What does that mean, repaired?
So repair means I got a default judgment taken against me, and rather than you file the motion to set aside the default, we will hire a lawyer to do it for you, and they're far better able. And what happens is we go to the client and say, you now have a conflict with your lawyer because you have a potential claim against your lawyer. If you agree, we will hire another lawyer to try and fix this problem. If we are able to fix it, your lawyer will continue with the case, and the fixing lawyer, the repair lawyer, will go away. And if you agree to all this, sign here. And 90% of the time they do. We don't do repairs if we don't really think we can get it repaired. I mean, we're not going to file a motion to set aside a default that was taken 6 months ago, because the chances that we're going to get it set aside is slim and none. So we only really undergo repairs that we really think we can be successful at. We looked at the average cost that we spend on repairs, and I'm making this number up, but it's somewhere around $9,000, $9,200, and you compare that to the average amount we spend on claims. The average claim is $20,000, so evidence that our efforts to repair end up saving money and obviously avoid the claim, and the client is happy and the lawyer's happy.
Sorry, excuse me. How many did you say were abandoned?
28%. Yeah. So talk a little bit about the claims against lawyers, the kinds of lawyers. So 68% of the claims that are made in Oregon are against solo lawyers. Solo lawyers represent 47% of all of our covered parties. So solo lawyers get more claims. There's a lot of reasons for that. Solo lawyers represent individuals. Individuals are far more apt to file a claim than companies are. And so I think that's the reason for it. If you look at the severity of those claims, it is absolutely the converse. The severity of claims brought against solo lawyers is the lowest, and the severity of claims brought against the largest law firms is the highest by a factor of 2. They get fewer claims, but they're way more expensive. Big firms are required, to be on our plan. Davis Wright, self-insured, every other office of the firm, but in Oregon, the first 300,000 was covered by the PLF. Nobody gets out. Big firms, small firms, everything. Again, that's the reason for the success, if you will, of the shared risk pool. Nobody. Part-time lawyers pay the same. Retiring lawyers pay the same. Everybody pays the same. Government lawyers? Government lawyers are not involved because they're not in private practice. The one exception is new lawyers, and by new lawyers, it's anybody new to Oregon. So you could be a 25-year lawyer, but you now, our primary resident is in Oregon, and you're practicing there. 40% discount in the first year, 20% discount in years 2 and 3. So that's the one exception. And that, the reason for that is simply they just don't have, they don't have any claim history that we need to worry about. It's a claims-made plan, so it reflects that. But we've talked about part-time issues. We get a lot of complaints from women about, this is hurting me, and it's discriminatory. We get this from the disabled lawyers about, the disabled lawyers that they should get a discount. We get it from people who represent low-income folks that they should get a discount. And we've looked at it, we've studied it, we've tried to analyze it, and it really, once you start going down, it's like, shut up, stop talking. Once you start going down that road, it is the proverbial slippery slope. And we have just decided to stay firm and have the program that we have. Okay, so I have been talking a lot. I would welcome questions, or the things on my list that I haven't addressed that you have questions about that I haven't talked about. Yeah.
Yeah, Carol, I just had a question about a couple of them first, but this concept of repair, is there any comparison anywhere in like the ABA statistics as to percentage of claims repaired? And I don't believe that there is.
Not that I know of. Yeah, not that I know of.
Yeah, because 18% seems like a fairly robust number. It does seem like a good number to have. Then the other question I had is, how do you interface with the public, in the sense of how does the public come to learn that the PLF exists, and how to submit a claim, and what does that look like?
Yeah. So we are, a part of the bar, but we are separate from the bar. We have our own board of governors. We have our own CEO, obviously. But we have a reporting relationship with the bar. The bar has to approve our plans. The bar, our policies. The bar has to approve our budget. The bar has to appoint my board members, on recommendation from us. So they do have a supervisory responsibility. But one of the reasons for the fairly robust wall between us is we are exempt from the squeal rule under the rules of ethics. In other words, we are not required to, nor do we report to the bar any violations of the rules of professional conduct. And they are not entitled to get access to our claims information. The bar, as a mandatory bar, its duty is to protect the public. We have a fiduciary and contractual obligation with the lawyer. And, what we say, and what I think is true, is the public benefits from our existence, but we do not have a duty to the public. Our duty is to the lawyer. So how do they find out about us? I think one common way is through the bar. When a complaint is made to the bar, that is really a malpractice claim, they will say, you should call the professional liability fund. And they call us and we will send them a claim intake form and they will fill that out. So the bar is very frequently, I mean, that referring folks to us. We do not do the other way around. We don't tell clients they should go to the bar because, again, of our fiduciary obligation to the lawyer. So we don't report them. We don't tell their clients to report them.
Carol, I was a little confused about some of the statistics. I think that you said that 18% of the claims your fund actually expends money for expense and indemnity.
Yes.
And then you also said that 30% of the claims are settled.
Right.
Okay, so if I take 18% of 11%, that means there's 2% of...
You're missing the claims that we settle without hiring outside counsel.
Okay.
So 14% we pay indemnity, but we don't pay any expense. So 14 and 18%, 32%.
Okay, thank you.
Mm-hmm.
Carol, thank you for being here today.
Sure.
Can you give us a little bit more information about what happens when the value of the claim exceeds the $300,000 limit? So some of your insureds buy insurance, excess insurance on the private market.
Mm-hmm.
And how many of the claims exceed the $300,000 limit? Maybe I'll just talk loudly back here. And what percentage of your claims exceed the $300,000 limit? What are the stats and
Sure.
the format on that?
Sure. So yes, there is, we sell excess insurance, so voluntary excess insurance up to $10 million. Again, our target market is the small and solo firms, and others buy it on the open market. So the number of claims since 1978 that the PLF has had, 28,175. The number of claims that went to limits, 165. So we don't, the average cost of claim is $20,500 currently based on our actuary analysis. So we don't get a lot of claims that go to limits. Obviously, if we had a huge securities case that we got the demand letter. I mean, we knew it was a multi-million-dollar case. They had other excess insurance. We basically handed our $300,000 over, and it was gone in 5 minutes. So that happens occasionally, rare, but it happens occasionally. But we work, hand in hand with the outside excess carrier if it's not us, and sometimes from the beginning, depending on our evaluation of the case. Is this on? Yeah. Okay. It plays a role too in our, evaluation of the case. We had a case recently where this lawyer, for reasons I cannot fathom, does not have excess insurance. She's a plaintiff's personal injury lawyer who, brings claims with, million-dollar demands at the bottom of the, complaint all the time, does not have excess insurance. And, we defended it. We were burning into the limits to some degree. I think we were at about $100,000 in attorney fees, so $50,000 of her $300,000 was gone. And it was a legitimate claim, and it had potential upside above that $250,000. And, we thought we could, though, we did think we could defend it. There was risk. But we really thought we could defend it. But with no excess, you're staring down the barrel of a bad faith case if you don't take the limits demand that you get. So that does happen from time to time where we settle cases, I think, for more than we should because this person does not have excess insurance. And not only are we looking at the potential bad faith case, but again, because we're this mandatory program, I think we really try and protect the lawyer, from herself in this case. And we felt, we had no choice but to do it in this case. So that happens from time to time.
So you are subject to bad faith
Yes,
claims?
we are.
Only first party, not third party?
Yes.
Carol, is there a consent clause for the insured, for the lawyers?
To settle?
Yeah.
No. No. I mean, we are able to settle without their consent. I mean, practically speaking, we almost never do that, but there are times. I mean, when I get the evaluations back, the one criticism, or the most common criticism that I get is we paid too much to settle the case, or we shouldn't have settled the case. I mean, as a trial lawyer, right, as a defense lawyer, you get the case, your client calls you, we're going to fight this, we're going to take him to, no way, we're kind of counterclaim, we're going to get our fees, and then they get the fourth bill, and they're like, when are we going to settle this case, right? So I think most of the time when I get those complaints from people, they only got the third bill. I mean, they're not paying it, but they're seeing, what's happening, or they've only, they haven't had to have their deposition taken, or any of that kind of stuff, so.
Consent
Carol,
for
this is-
choice of counsel?
No. But again, we always, we always will say to them, here are the 4 or 5 people. And occasionally they'll say, I really want so-and-so who's not on our panel. And so long as their rates are within what we will tolerate, we don't have a rate grid or anything like that. But so long as they're willing to do it at rates comparable and there's not another reason not to take that person, we will often do that.
Carol, this is probably more of a California phenomenon than an Oregon phenomenon, but do you ever have situations where in the defense of the case, the limit is expended, but there's no excess insurance? And what would you do with something like that?
Yeah, I mean, it happens, with rarely, but, 90% of the time, 98% of the time, the other lawyer knows what the situation is, that this person has no excess, and are they really going to want to go after, do they want to become a foreclosure lawyer? Do they want to go after this person's assets? Putting aside the, whether they feel good about that, do they want to go through that hassle? So typically what happens is early on, when they know whether or not there is excess insurance, they will, they'll make a policy limit demand sooner rather than later to get as much as they possibly can. So.
I wanted to go over to Ruben and then Scott.
Thanks. Carol, you mentioned, I think jokingly, at your beginning of your remarks that there would be a revolt if the program were to be ceased, or a revolt if it were attempted to be started at this point. Have there been efforts to discontinue the program or make it optional? And if so, do you know who or what was behind that?
Sure. There haven't really been efforts to discontinue the program. There have been legal challenges to it. Back in the 80s, there were some challenges to it based on, sort of constitutional grounds. I mean, not unlike the kinds of claims that are being brought against, unified bars of late. In the last year, I would say, is the first time that we have started to have folks say, why do we need this thing? I mean, what you will hear people say is, I used to practice in fill in the blank, and I got this much insurance for half the price that you're charging me. And, why should I be paying this much money? There is a robust open market in every other state. There's no reason to doubt that there wouldn't be a robust open market in Portland should the PLF go away. And so why do we still need this? But I will say that those voices are the exception. Again, there's a little bit of something for everybody, because of the robust nature. Half of our covered parties are solo lawyers. And the loss prevention services that we provide are worth a ton to those folks, and they really value that. And I think so they are kind of on board with that. Then the smaller firms, so up to say 30 to 50 lawyers, they do get claims, and it's $1 coverage, and they're small enough that to have either a deductible or to have to deal with a claim, would be very disruptive to their life and to their practice. And so they so appreciate being able to hand this over to lawyers who they feel are good, and I think the quality of our claims attorneys is excellent. It's just a big relief for them. Interestingly, the lawyers that have more consistently been opposed to the PLF are the big firms, because we can afford to be self-insured at that level. Why can't you carve us out? So there, it has not been a big, let's take this to the bar for a vote kind of complaint, but it has been, over the years, far more frequently than solos, far more frequently. Solos really pushed to get us to underwrite, to charge less for part-time and low-income lawyers. So. There it is. Oh, nope.
I was just wondering if you have any statistics on the amount of lawyers that get sued out of state, and also how your coverage works with respect to them getting sued out of state.
Yeah. So we cover you with any lawsuit in the United States or Canada, if you're sued in the United States or Canada. I don't have those statistics off the top of my head. I would say, probably fewer than 5%. And certainly in the 4 years I've been there, we don't have a ton. Obviously Washington, California being the most common ones. But any other questions?
I have a question.
Earlier, you indicated that lawyers are covered regardless of claims history.
Right.
And your job is not to report to the state bar any claims that are made. Do the lawyers themselves have an obligation to report if they have a judgment or a settlement?
No. And one of the things I say, and in fact, we were on a panel, Randy and I and Linda, at LPL back in November, and one of the speakers, who was terrific, but talked about why she was in favor of mandatory malpractice, not necessarily captive fund, but she used the term lawyer malfeasance, and I think yes, we have some claims involving lawyer malfeasance, but the vast majority of our claims are just simple mistakes. People make mistakes. And this is a profession that is requires judgment, and sometimes you make a mistake in that judgment, and sometimes it's not a judgment, it's just you can't possibly read a calendar correctly or something. It's amazing how many claims we have that are statute of limitations. It's just like, how? I didn't understand this law, or I didn't realize there was this thing that I had to do, or whatever it was, and but your basic motor vehicle accident, that you cannot file on time when the statute of limitations has been 2 years since, Moses. I don't understand it, but it happens.
Scott?
I apologize if someone asked this, but how many lawyers do you have in Oregon, and how many employees are used to sort of work the fund, or to make the fund go?
Sure. So I don't know what the total number of lawyers in Oregon is. It's somewhere around 14,000, 12,000, something like that. But the covered lawyers, so the lawyers that meet our definition, is about 7,200 lawyers. Yeah.
And how many people are in your program as employees?
As employees, 50. So that includes the loss prevention side of things. The 4 attorney counselors, the 4 practice managers. We have 12 claims attorneys, which includes a director of claims. The claims attorneys handle somewhere around 75 cases that they handle, which for many Nabrico companies is way lower. And again, that's part of our commitment to having significant involvement among the claims attorneys with those claims.
Are the employees state employees, or is it a separate entity?
We are this we are an instrumentality of the judicial department. So we are, we are PERS covered, which happened actually sometime later. But we are public employees, yeah.
I actually had a question. So when PLF started in 1978, I was just a child then,
Yes,
by the way.
yes.
How did you deal with prior acts, if you know?
I don't know. I don't know what they did.
So
It's
that's a
always
question-
been a claims-made policy, so I'm assuming those were covered, but I don't know.
Yeah, that is, I think, the right answer in the sense that a claims-made policy would pick up some of that.
Yeah.
But it is a practical question we get a lot if
Yeah,
a
yeah.
program like this were to
Yeah.
incept
Yeah.
here, especially in California. What do we do about the stuff that's lingering out there?
Sure. Sure.
And then in terms of the capitalization, Carol, and my quick math was for $500 a policy, at least in the old days, and I sort of estimated maybe there was about 5,000 or 6,000 lawyers that would qualify or would be insured
Yeah,
under
probably
the.
fewer than that. I'd say
Yeah.
it's probably closer to 3,500. But
Okay.
Okay.
Well, yeah, the math would be a little bit different then, but probably a capitalization would be $2 million, $3 million, I guess was the math with 6,000 insureds times $500 premium. And I know it's radically different today, but how just sort of using that as an example, because the math is a little bit easier, how do that capitalization break down in terms of expenses, indemnity, staffing,
Yeah.
paying your claims counsel, internal, whatever else,
Yeah,
components of that?
I mean, I don't know the numbers exactly, but I would say it was, 85% was paying for claims, whether indemnity or defense counsel. We had, fewer than 5 employees in the first 5 years of the PLF. So, it was a very lean shop because there was no money really beyond what we needed. And that's, then we began to develop the reserves that we needed, so.
Right. So nowadays it's obviously different, but would you say the percentage of the capitalization or the annual budget, just to simplify it, is paid out in the form of claims expenses? Indemnity and claims expenses?
Yes,
Okay.
yeah. Yes, most definitely.
Okay. Who did I get?
Carol, you gave the example of the plaintiff's personal injury lawyer who had the coverage but didn't have an excess.
Right.
What efforts are made by the PLF to convince, persuade, cajole
Yeah.
lawyers to
Yeah.
get the appropriate amount of coverage given their practice?
We have, we started offering excess in the early 90s because, again, it was hard for some lawyers to get excess insurance. It was a similar kind of market. And we didn't push it. We just sort of said it's here, it's available. We didn't. But lately we have been pushing that a little bit higher. We get a lot of times what we get from folks is, well, why don't you raise the mandatory amount? Why don't you make it $350 or $400 or $500 or something like that? And the reality is not everybody needs excess insurance, and so the question is trying to get people to analyze for themselves what's the right amount of coverage. I think, it's one of the things that I've talked to the LPL committee about of the ABA of developing a tool that people can use, sort of a questionnaire for yourself of how much insurance do I need? But what I said to this lawyer who was there at the mediation, I said, it does not work, and I know I'm preaching the choir here, but if you're going to bring a complaint that says that your prayer is $1 million, for you to defend the malpractice case that the claim was meritless, I mean, you're either lying then or you're lying now. It's not a great strategy, So if that's what you're saying is your that you're bringing claims at that value, you need to have protection at that level, so, or close to that level, so.
See if I can come on here.
It appears I have the only microphone that works in the entire place. Lucky me.
I gotta say, you probably have the best microphone in the group, but I just had a couple of quick questions about the assessment.
Mhm.
I would have brought my own. So for a
Here we go. Here you go.
Marcus worked his magic. For a firm of 10 attorneys, so there would be a $3,500 assessment for each attorney?
Yes.
And then how does, let's say you have a partner and an associate on a case, does the limit stack? How does that work?
Okay, so we insure the lawyer, we don't insure the firm. So every lawyer pays $3,300 as of January 1st. And there is a single limit per claim. And so those shared limits can be in the firm, or it can be across firms. Two lawyers worked on a matter in different firms, and so there will be one limit in that situation as well.
Okay, we have to move on because we have Professor Spitzer that's going to go on right at 11. He's going to be with us by video conference. And Professor Spitzer is an active professor and has a class schedule, so I know we've got to slot him in. So I apologize to those of you that have additional questions or thoughts on this. It's obviously an important topic. And Carol, thank you for so much for sharing as usual, all of your intelligence and expertise with us.
It's my
here. It's
pleasure.
very
Thank you for
valuable.
having me. I'm actually going to, if it's okay, just sit and listen. I have to leave about 1:30 for the airport, so.
We'd love to have you
That
stay.
would be
Okay.
great.
So, Mr. Webmaster, I know you've got to queue up Professor Spitzer, so here we go.
Oh, here he is.
And Glenn, we'll start with you or Mark for an introduction for Professor Spitzer, and then we're ready to go.
Okay. Here we go. So I'll tell you how we got to Professor Spitzer. Can you hear us okay, Professor?
I can. I can't see you, but I can hear you fine.
It's okay. You're better off. We were led to Professor Spitzer because he is chairing the Mandatory Malpractice Insurance Task Force for the Washington State Bar Association. And on July 10th, 2018, they issued their interim report to the Board of Governors. It's 10 pages long. It was included with all the materials. And this is the roadmap for us to follow, actually, this wonderful report. And it's something that actually kept my attention the entire 10 pages. Professor Spitzer graduated from Yale. He's got his law degree from the University of Washington. I'm only saying those two things because of the third thing, which is he's got his LLM from the University of California, Berkeley. So there's your California qualifications. He's currently a professor of law at the University of Washington. He teaches professional responsibilities, state constitutional law, local government law, and transactional law. He's published widely on local government and state constitution law practices. So we're very lucky. He's the chair of this report. It's a great report, and he has been most gracious with his time. We've called him and bugged him a number of times, and he's answered all of our questions. So we have about 55 minutes, and what we've done is we've divided this presentation into 4 parts. And so each of the parts has 2 or 3 questions. And if you would hold your questions until we're done with a part, then we'll take questions, and then we'll move on to the next ones. So grouping number 1, Professor, is please describe the charge of the committee that you chair in Washington. Where are you in the process of making recommendations? And the third question, your committee has published tentative recommendations. Can you describe them for us?
Sure. So I'm very happy to be here this morning and update you on where we are in Washington on this process. The task force that I chair it was appointed by our Board of Governors last fall, and that is fall of 2017, and we've been working diligently all year, meeting at least once a month, and then with some subcommittees meeting from time to time. We have 17 members. It includes lawyers from around the state, one triple LT, which is a limited licensed legal technician. We have people from the insurance industry, a broker, and members of the public, and also one federal judge. The charter from the Board of Governors asked us to focus on taking a look at my notes here, to the nature and the consequences of uninsured attorneys, examine the current mandatory malpractice insurance commissions that exist, systems that exist, and to gather information and comments from our bar members and interested parties, and then come up with recommendations on whether to recommend mandatory malpractice insurance, and if so, what model might work best in Washington State, and then start drafting rules to implement the model. So that was our charge. And in terms of the process, what you've got there is our interim report that we sent to the Board of Governors last July. Since then, we've continued to gather data and to refine and expand our recommendations. About 2 months ago and 1 month ago, at the last two meetings, we really settled on our recommendations and nailed them down in much more detail. Right now, three of us are actually drafting the full final report. It's going to be at least 3 times as long and 3 times more detailed than the interim report that you have. We're aware of the situation in Nevada where and I don't know the real background there, but what their court said was that the case hadn't been made sufficiently to them, that there was a need for mandatory malpractice insurance, and our task force continues to think that it is the best approach, that is some kind of mandatory insurance system. And we've also heard from a lot of members of the bar, had hearings and gotten a lot of written comments. We've taken those into account. So where we are now, we have several recommendations, and I guess I'll mention the issues that we looked at, or the models that we looked at, are still basically the ones that are described in the report. Do nothing. Implement an Illinois-style proactive practice management system. Implement much more disclosure, like in South Dakota. Do some kind of a combined system of Illinois and South Dakota. Use a free insurance model, or go with an Oregon-style system of a kept insurance company, or a bar-operated professional liability fund. We also looked at some other kinds of approaches, like having lawyers come up with letters of credit, or performance bonds if they didn't want to buy insurance. So what we will be recommending is, number one, that all active Washington licensed attorneys engaged in private practice, they would all be required to maintain continuous, uninterrupted malpractice insurance with specified exemptions. Attorneys would be required to obtain minimum levels of professional liability insurance in the private marketplace. So we would go with the kind of Idaho model of free market with a required minimum coverage of 250,000 per occurrence and 500,000 total per year. So 250, 500. And this requirement we're recommending be implemented through court rules. In Washington state, the practice of law is almost entirely governed by the court, and the legislature doesn't have much to say about it. What the legislature has to say is only to the extent that the court lets the legislature have a say. So that's our basic recommendation. The exemptions that we'll be recommending are government lawyers, in-house private sector lawyers, both for-profit and non-profit. And again, this is if those lawyers have their entire practice working for the government or entirely in-house. And then lawyers, another exemption class would be lawyers who are working for a qualified legal service provider. That's like legal services and the public defender entities that are nonprofits. And then also lawyers who volunteer on a pro bono basis, but through one of the qualified legal service providers that themselves provide coverage, malpractice insurance coverage for the lawyers who volunteer through them. We recommend exempting mediators, arbitrators, judges, ALJs, hearing officers, law clerks, and then other lawyers who either are not actively licensed or who are not engaged in the private practice of law. And basically here we're talking about retired lawyers who choose to keep their law licenses up, either because they might want to go back into practice or because they want to wait till they can get their 50-year PIN and then retire. And then finally, we're recommending that the enforcement and monitoring for this be done through our annual certification and licensing system. Basically, lawyers would simply have to certify annually when they renew their licenses that they are compliant and they will continue to be compliant. And then the failure to comply would lead to an administrative suspension, and it's a fairly straightforward process. The bar disciplinary people would be able to monitor and basically do random checks, just like they do now on people's trust accounts and CLE compliance and so on. So that's basically where we are. We expect to have our report done in a draft probably for the meeting at the end of this month for our task force. We'll keep working on that in December, and we'll have it to the Board of Governors by the end of January or the beginning of February. It'll be on their agenda, I expect, in their March meeting next year to discuss.
Okay.
So that's kind of the first group of questions that you had.
And how many lawyers are licensed in Washington, and about how many are you expecting that will be covered by the program?
Right. So we have right now 26,000 active lawyers and a few thousand in other categories, but 26,000. 2/3 of those would likely come under this requirement, maybe as low as 60%.
Great. Does anybody have any questions before we move on to the next groupings, which are going to be more specific? Yeah.
I have a question.
Sure.
Professor Spencer. Did your committee contemplate what to do if a lawyer is uninsurable based on claims or some other disqualification?
Yeah. Now, uninsurability is, in a sense, in the eye of the beholder. The insurance professionals told us that there is no such thing as an uninsurable lawyer. Of course, at some point, the cost of insurance might be generally regarded as prohibited. But in Idaho, as you probably know, there are no reports, at least that we have, of any lawyer being unable to get insurance. In theory, I imagine that, I mean, there might be some lawyer who even the providers of special lines would be unwilling to insure. But the general feeling on our task force is that one lawyer or two lawyers at most are perhaps like the surgeons who can't get liability insurance so that they get admission privileges, and you might not want to pick that surgeon to go to work on repairing your spleen.
Just as a follow-up to that, Professor Spitzer, did your committee consider the notion of the private insurance market sort of dictating who can practice law in Washington through the risk profile of that particular lawyer?
Yeah, the answer is yes. And again, all indications that we have, particularly from ALPS, which is the provider that works, has been designated through a competitive process to work with our state bar, they appear to provide, and I happen to be covered, by the way, because I still do some consulting, and I have a very reasonable policy. They appear to be able to provide for just about anybody at reasonable prices. So when you get right down to it, we're not concerned that the industry would be dictating. We think that the free market system is more flexible and is going to work out to be the lowest rates for the greatest number of lawyers, and that the number of lawyers who would wind up having to go to special lines and pay more than they might like is going to be pretty small, so that we don't view this as really an issue of the insurance industry dictating who can practice law any more, again, than the insurance industry could be said to be dictating who gets to be a doctor with admitting privileges.
Or perhaps they come to California to practice.
Well, yeah, I don't know. Are you talking about the docs or the lawyers?
I just.
They have to
Hi,
pass the
Professor.
California bar too, and that's even tougher than ours.
Hi, Professor. Thanks. I just had a quick question. I don't know if I missed it, but did you say what the minimum amounts would be required of limits, and would there be deductibles, or that's just discretionary?
Could you repeat that, or somebody closer to the
I'm
mic?
sorry, what the minimum limits of the policies would be, and is there a deductible requirement? Would there be something outside the limits, or any other parameters related to that?
Yeah. So once again, can someone who's right by the mic repeat the question?
Yeah, the question from Mr. Barabat was, Professor Spitzer, if you can hear me, what were the limits that were you anticipated being offered under the mandatory program, and the amount of the deductibles, if that was considered?
Yes. So we considered possible coverage level requirements at 100, 300, 250, 250, and 250, 500. Now, these are relatively low, but they're kind of consistent with, what we're seeing. Oregon, as you know, is at 300. Idaho's is 100, 300. The Idaho 100, 300 seemed too low to us because we wanted to make sure that there would be sufficient amounts if you have a cannibalizing policy, that is where you're eating into the coverage in order to cover the defense. We wanted to make sure that there was enough. And we were concerned that 100,000 might not be sufficient to cover the cost of payment to a successful claimant plus the amounts to pay the defense lawyers. And we then looked at 250, 250, but to go up to 200, 250, 500 was just another 100 or $200. I actually asked for my, because I'm doing my renewal for next year. I asked them to give me quotes at 100, 300, 250, 250, and 250, 500 for me. And the difference to go up from 250, 250 to 250, 500 was about $80. So now I'm not full time, but I talked to the people and they said we're looking at a couple $100 more. And so we felt that a minimum coverage of 250, 500 would be sufficient to cover the large majority of claims, up in the 90 percentiles somewhere of claims, without any problem at all. So that's how we landed on what we're recommending. It's interesting, by the way, that you look at other countries, and in Canada, as you'll talk to or have talked to the person there, and Germany, Australia, Singapore. Most of these places have coverages of $500,000 to $1 million, $1.5 million, and so we're fairly low, but we're trying to keep it affordable and again covering the vast majority of claims.
Hi, Professor. This is Scott Garner. Thanks again for presenting. As I look around our room here, I sort of wonder how in the world we're ever going to reach a consensus. And so I'm wondering if you could just take a couple minutes to explain how your group came to a consensus. Was it just a straight line vote, 10 in favor, 9 opposed, whatever it is, that could just give us some insight into how you would get a group to arrive at specific numbers, the private market as opposed to a captured, those types of issues?
Yeah, we did not have a lot of trouble. People, when we had our first meeting, we went around the table and people said what their gut feelings were, and they were all over the map. And then we started gathering data, and we heard from industry professionals. We had people from Idaho, Nevada, Illinois, Oregon, of course, and then we were hearing from members of the bar. And somehow, all I can say is it was organic, and we just all started gravitating toward this free market model. Anyway, maybe I'll just move on to this group number 2 of questions, because we looked at the Oregon system. It's a great system. It's kind of gold-plated. They have an excellent staff. They have wonderful support for the lawyers. They're very proactive in dealing with potential claims and just getting them dealt with. And so it's really a great model, but it's expensive. And we felt that we would have a hard time selling the Oregon model because what lawyers there are paying. And we were really looking at what's it going to cost to get the solo and small firm lawyers, who are the bulk of the uninsured lawyers, to get them insured at a level that's going to cover almost all of the claims that might be made, get them up and running at a reasonable cost. And we were just concerned that $3,000 a year plus, and maybe it would be plus in the initial years, it would just be too hard on people, and there would be too much resistance. The other thing is, of course, you need staff, you need capital, and it takes a long time to get a system like Oregon's up and running, and we wanted it to move more quickly. Also, and this is still part of this group 2 set of questions, in this state, it's probably similar in California, but I don't know. We've got 33 carriers who are writing insurance for solos and small firms. Of those, and we have 28 that are writing for large firms. And then of those carriers, 21 are admitted carriers. So they're registered with the state insurance commissioner and the state commissioner's kind of insurance on insurance program. 6 are non-admitted, and then we've got 4 retention groups like ALAS or ALAS. And so the bottom line is we've got a robust private market here. It's quite competitive. And so we felt that we would, in a sense, get more bang for the buck and get the most people insured at a reasonable cost by going with the private market. And there was a lot of argument about that, but ultimately we didn't have trouble getting consensus on that for us. I guess one other consideration was the Oregon or a captured insurance system. You've basically got cross-subsidization going on, and you have really the bulk of the lawyers subsidizing the lawyers who are the toughest to insure. And we just had a little more of a libertarian free market approach that people who are tough to insure should be paying for it. Another thing that was convincing to us was that, as you probably know by now, when people who haven't been insured are just coming into the market, they're paying relatively low rates because they don't have past claims that the insurers have to worry about since they're writing on a claims-made basis. And then you've got people's rates going up for maybe 15% per year. So over 6 years, it might double. But there's a slow ramp up, and we felt that that was quite reasonable. Correct. Yes. We actually had people testifying at a hearing who we had one guy who came up and he said there were 6 people who had been served by the same lawyer, and he was one of them. He wound up losing some property. The lawyer simply was not diligent and was not tracking what was going on. And half a dozen people had judgments against them, and they were enforced. They turned around and tried to seek compensation from the lawyer who filed for bankruptcy. And we've talked to a number of malpractice plaintiffs' lawyers who recounted, again, specific instances. It's extremely hard to track in terms of, hard numbers. All you can do is hear people's stories and, either the individuals or the lawyers who represent them. And, but definitely the issue is there. Do you want me to move on to the next group of issues?
Yeah, not yet. First,
Okay.
in response to Scott's question about the process, were there people on the committee when you went around the table the first time who were opposed to even the concept of mandatory insurance? And,
Yes.
Okay. And how
Yeah.
did that organically?
We had 1 or 2 who were pretty firmly uncomfortable with the idea or skeptical of the idea, maybe 3. The rest of them had a gut feeling that it was probably a good thing, but I would say the majority of people wanted to nail down that there was a problem because we didn't want to solve a problem that didn't exist. And we've come to the conclusion that there is a problem.
And one last question before we move on to group 3 would be what considerations, if any, did you give to the situation if the open market for mandatory insurance, if that was what was adopted, if the number of carriers started to shrink and it became a hard market as opposed to a good market as exists now?
Right. So we've talked about that. It certainly could happen because, as you know, whatever, 30 years ago, the market was very different from today. Our feeling was that we should move ahead and recommend, a mandatory insurance system. My hunch is that if the economy, the specific economy in this business changed, and it was getting really difficult for people to get even small amounts of insurance at a reasonable cost, I imagine that the lawyers would ask for the formation of a pool, like in Oregon, and that would probably happen. We talked about it. We felt that given the robustness of the market today, that we should move ahead.
Okay, great. All right, the next group also has 3 questions. First, are there particular stakeholders in Washington that oppose mandatory insurance for lawyers? And what have their positions been? Second, if LPLI insurance is mandated, how does Washington propose to handle the issue of lawyers with significant claims experience? And third, do you have any thoughts about the steps that would have to take place in California to get a captive or state-run primary insurance program in place?
Right. So we've received comments from, by now, about 440 or 450 people, mostly lawyers. And of those, let me see, looking at the summary here, about, it's hard to say, but about 25 or 30% of them are just dead set against a requirement. The largest number of the comments were concerned about exemptions. They just wanted to make sure that they weren't going to have to get insurance because they were government lawyers or whatever, or they actually weren't practicing law. But when you boil down the opponents, and there seem to be, at least we've heard from about 100 very firm opponents, and there are 2 or 3 of them who are sending repeated communications to the members of the Board of Governors and the members of the task force and everybody just about every day. I think they're not practicing very much law, but they're quite busy in critiquing where we're going on this. The people who don't want it seem to be solo and small firm lawyers who don't want to pay for it. Number one, I think that's the bulk of it. They just don't want to have to pay. We're talking about people paying $1,500 a year, $2,000 a year, not unreasonable amounts, at least in the view of people on the task force. And then we have people who just have a libertarian view and who think, well, it's up to the clients. The client should be able to just say they don't want a lawyer who's uninsured. What we have found, although I can't say it's fancy empirical data, it's just what we've heard from people as we've been doing our work, is that a huge number of lawyers and a larger percentage of the public just assumes that all lawyers have insurance and are flabbergasted when they hear that they don't. Even though the data is up on the Bar Association website, it's not an easy website to use, and I don't think very many clients log on. I really should find out how many people actually, well, you can't tell because they're just logging on to the data about their lawyer or any lawyer, and you don't know what they're looking at. But most people, we've concluded, think that lawyers are already covered. But again, bottom line, the people who don't want it are lawyers who don't want to pay. And our view, and it's really a unanimous view in the task force, is that we're not here to look out for lawyers. Sorry. Our job is to look out for the public and protecting clients and the public. And we know that our court has that view. and so we're making a recommendation on what we think is going to protect clients. Now, again, what do you do with people who have significant claims experience? They're just going to wind up paying more, although most of them, I think, it's going to wind up being reasonable for them, but some of them maybe not. In terms of moving to a captive or state-run system, we really don't have any advice on that. I think Oregon would have the best advice. Maybe Ontario, if they have a captive system. All I can think of is that it will take a long time. You want to get it right from the get-go, so don't try to rush it, and make sure that you have adequate capital and rates that are going to cover your initial funding of a pool, a reserve. So those are my answers to the group number 3 batch.
Professor, this is Joanna Mendoza. I'm with the Board of Trustees of the State Bar. The question I have is whether or not your task force considered the access to justice issues associated with the recommendation you're going to be making and the disparate impact it could have on attorneys that are people of color and the clients they serve. You know, that's a different aspect of public protection we want to be very sensitive to. So did you look at that?
Yeah. Yes, we're extremely sensitive to that. That is a concern because, as you know, the percentage of solo practitioners and very small practitioners who are persons of color is higher than in the lawyers as a whole. They often are serving underserved communities, so that's definitely an issue. But after a lot of discussion, we concluded that, again, it is not fair to the clients, particularly clients who are in underserved communities, to have to bear the risk of having a claim and having loss that can't be compensated. It is a difficult issue for sure, but on balance, we just thought we've got to do this to protect the clients. The other issue that we were very concerned about and continue to be concerned about is the retired lawyer or the government or in-house lawyer who's doing some pro bono work on the side, but not through a qualified QLSB, that is a qualified legal service provider, QLSP, who has insurance to cover the volunteer lawyers who work with them. So we're talking about, we think, about 1/3 of the pro bono work that's going on. And we're not talking here about lawyers who are just, doing some work for free for somebody who comes in. We're talking about people who are working typically with nonprofit organizations or through nonprofit organizations, but they're not getting insured through that and they don't have their own insurance. So we are going to recommend and make a very strong recommendation to the bar that they work aggressively to make sure that every county county in the state, not just the 2/3 that have it now, every single county in the state is somehow covered so that lawyers in those counties who wish to do pro bono work can do it in that county through a nonprofit that will provide insurance for them if this is the only legal work that they're doing. So that was a concern. And actually, it was, one of our greatest concerns.
Professor, thank you. This is Heather Rosing. I'm one of the working group members. When I read your report, the report that came out of your task force in Washington, I was struck by the fact that you have better data than us. They know the breakdown of their attorneys. You know the breakdown of your attorneys. You know how many are insured and uninsured. We don't know that. And I'm just curious, how did you go about collecting that data? I suspect maybe you asked for it when people need to register for the mandatory dues every year, but how did you get
Yeah.
all the great data that we don't have?
Yeah, that's right. We have a court rule that requires every lawyer to certify when she uh, pays her license fees every year. You have to certify uh, whether or not you have and plan to continue to have malpractice insurance coverage, number one. Number two, you have to certify whether or not you have a trust fund or not. And then you have to do your MCLE certification. So because we are collecting that data annually, we know precisely how many people are insured and how many people are uninsured. And we assume that they're being honest. I expect that they are.
Thank you.
Yes. And I thought we mentioned that in the report. Maybe we didn't. I don't have that data handy. We've got the data. Um, all I can tell you is that we know that the lawyers who are in solo to 5 have, here we go. This is what we reported before. 14% of lawyers overall in the state don't carry insurance. 28% of the solos report that they're uninsured. So it's twice as many solos are uninsured than the overall percentage. No. This is private practice. Yeah, and if you want to nail that down, you could get in touch with probably Doug Ende, who's the chief disciplinary counsel, or Thea Jensen, who's his Thea Jennings, his kind of chief of staff. They can probably cook up that data for you. So the one question was, how did we decide the coverage levels? And I already discussed that. One thing I didn't mention in answer to an earlier question is that we decided not to get into deductibles because the insurance industry professionals, underwriters, brokers just said, at least the way things currently stand, for almost everybody, the amount of deductibles that they allow are in the $2,500, $5,000 range, and maybe somewhat above that. But they just don't do $100,000 deductibles or $50,000 deductibles. If somebody started writing those policies, we might come back and do something. But our overall theory was that we don't want to mess with the private market and to dictate the kinds of arrangements that people put together within the sort of standard kinds of policies that are there. And again, we wanted to set the requirement at a level that's not so high that it was too expensive, but not so low that it wasn't going to pick up the vast majority of claims. And then the last question was whether we considered simply requiring much heavier disclosure, like in South Dakota, and we considered a system where you might have a super system of South Dakota, where you require that on every piece of paper, on a lawyer's card, on a lawyer's stationery, on every letter that he or she sends to a client, that it says on there in the same, on a prescribed font size, this attorney does not carry malpractice insurance. So we thought, well, we could do that, plus the Illinois PMBR system, but maybe a little bit tougher, where the lawyers have to pay for the assessments, and they don't get CLE credit for it. So we talked about that, and it looked pretty attractive. But ultimately, our concern was that the clients would not have the protection there when they needed it for those lawyers who went ahead, did all the disclosure, and did all the courses. We're just worried about the clients. It does look attractive, but ultimately we decided not to go that way. And that was something we voted on. And there were some people who thought maybe that would be a better way to go. Sorry for the background noise. I don't know how to turn that one off. So.
Yeah, Professor, this is Glenn Olson. I just had a question about, it's kind of a combination of disclosure and the mandatory insurance requirement, but was there any discussion about what happens if in the midterm, for whatever reason, a lawyer's insurance is canceled, and what the requirement would be on the lawyer to disclose that fact either to the bar or to the clients?
Can somebody right next to the mic repeat that question?
I think your mic is on, and maybe it is only hearing one mic.
Right. Right. So our recommendation will be, and the rule, we're actually drafting a rule now. So when we do our final report, proposed rule will come along with it. And it would require that any lawyer who has insurance lapse has an obligation to promptly, within 30 or 60 days, I can't remember, inform the bar. And then they're going to be put on administrative suspension if they don't. I guess they would have in fact, I think we have the details already on that one. We worked that out. Let's see. I don't have the number of days, but it would be just the same as when lawyers don't comply with their mandatory CLE requirements. They get a period to fix it. I think it's 90 days. It might even be 6 months, but I don't think this would be 6 months. I think it's either 60 or 90 days, and they have to clean it up. And if they don't, they go on administrative suspension, and then their license is suspended till they get things worked out. And I've got about 5 minutes, and then I have to head to a meeting in another building.
Hi,
Okay.
This is Lisa Parachet. I'm curious if you explored the cost to the bar of implementing either the one you're recommending or captive administrative costs that would be new costs to the bar.
Yeah, right now we think it looks like a 0.5 FTE, so 1/2 of a person. Not too much, because it's all through the certification process and then checkup process. So the staff people think it's probably 0.2 or 0.25 of a person, just to kind of making sure everything's getting lined up right, and another 1/4 of a person doing random checks.
And did you also look, though, at the alternative, when you were considering possibly doing captive, did you look at the costs that might be associated with that?
Yeah, so we didn't look at an outside captive. We looked at the Oregon system, and as you know, they have a robust staff. And I can't remember how many, but they've got what, maybe a dozen people, something like that. They have a lot of people, and that's what you pay for. But they do a great job, really great job.
Carol
Although
is
we're told,
sitting right
we're
here
told
with
that
us.
Oregon lawyers are, when you poll them, they say, yeah, I'm happy with the system. And then if you ask them, if you didn't have this system today, would you want it? A majority of them would say, no, we'd rather go free market. But they're used to it, and they're happy to have it. It's a good system.
We're beginning to think that you're a shill.
Yeah.
No, I'm not. I mean, I'm a free market person, and I'm not. I don't think it's right in our state, and it's just too much to put together and winds up being too expensive. But I admire their system.
Great. Well, we promised to end in about 1 or 2 minutes. So if any other questions? No? Professor, thank you very, very much for giving
My
us your
pleasure.
time. And
Good luck, and you'll see our report coming out in a couple of months.
Great. Thank you.
Thank you so much.
Thank you. Bye-bye.
This is essentially a blueprint for
Hi, Dan. Can you hear us? Dan, are you able to hear us? Testing 1, 2, 3. Dan, can you hear us? Dan, are you able to hear us? Testing 1, 2, 3. Testing. We're not able to hear you. Okay, you know what? Can you text me your cell number or a landline that you can use a speakerphone? I'm going to use the to connect to you so that way we can get audio from you. Because apparently we can't hear you. Let me see. Can you hear me? Testing 1, 2, 3. Say something. Yeah, I'm not able to hear you. Um, I see you. We have visual, but we do not have audio. Check to be sure that when you started your Skype session, did you do full Skype experience, full Skype video and audio? You should have. Um, yeah, let me see if I can. Linda, do you have Dan's cell number? Because that way, worst case scenario, I can dial him into the audio conference. Okay, yeah, that will work too. His landline actually is probably more reliable. Okay, he's logging in right now. Dan, you're slowly logging in, and your microphone is muted. Let me see if I can unmute you. Okay, can you give me a sound check, please? No, I'm not able to see you. So, what is the best number for me to call you right now? Through your cell phone or your landline? Okay, Linda has the landline, so I'm going to try to dial you then, okay? Okay.
Hi, it's Dan. Hello?
Hey, Dan, can you hear us?
I can hear you. I need to kill the audio on my computer. 1 second, Eric. Okay, audio on the computer is killed.
Excellent.
How is the
Okay, so we can hear you loud and clear, and we see you clearly. Okay. Okay, Dan. You are ready for presentation. They're still at lunch. They should be reconvening in momentarily.
Okay, so I need to click on the present button.
Pardon me?
I'm gonna click on the present button here. Because I need to make myself the presenter and upload the PowerPoint file, right?
You are now the presenter.
I'm uploading my PowerPoint.
Quick question. I didn't do my homework as much as I should have. But so there's no aggregate limit in Oregon. Yeah. There's the 300,000, and if somebody does see gets sued in January.
No, it is the 300 aggregate limit. Yeah, 300 per claim and in the loss.
So what happens if the guy gets another lawsuit 2 weeks later or months later?
Whatever's left is there, and if there's nothing left, he's on his own. Okay. He has no excess. Yeah. Yeah.
That's the way to handle bad lawyers.
Yes.
PowerPoint is uploading.
I know. This is so great.
Okay, it looks like I'm uploaded and ready here.
Hi, Dan. This is Glenn Olson. Can you hear me?
I can hear you fine, Glenn.
Oh, great. Okay. We've been kind of working with the microphones a little bit here today. So, Randy, I don't know what our schedule is, whether we should get up and running now, if that will work.
Let's start up. I think we're ready to go. We want to keep it on track, and Dan is teed up. Thanks, Dan, by the way.
Yeah.
He's teed up at 12:15.
And let me give you just a short intro. Dan is the president and the CEO of LawPro, which is the lawyers' professional indemnity company located in Toronto, Ontario, and is really very much a specialist and an expert in the topics that we're talking about today involving captive insurance. And Dan was also the driving force behind Practice Pro, which is a very strong loss prevention initiative that LawPro has in place and is a big part of their program. So, Dan, I wanted to thank you for spending time with us today. And I know you have spoken at one of our previous committees of the California State Bar, and we found it very informative. So thanks again for speaking, and I will turn it over to you.
Great. Thanks so much. Great to have an opportunity to spread a bit of the gospel about what we've done here in Ontario at LawPro and talk about mandatory captive insurance programs, which is our experience here in Ontario and the other jurisdictions across the country here. I've got 80 slides or so to get through in the next 45 minutes, so we will move along. Supplemental materials were provided, and I'll give some, happy to leave some time for some questions at the end. I'm going to give you a little bit of an historical perspective about where we got to today. I think that's going to be helpful because my guess is you may follow a somewhat similar path. Talk about the LawPro program, talk about the causes of claims, which is important because we have a unique perspective. Because we insure everybody, we see all of the claims, and that's a fairly unusual perspective in every jurisdiction in the U.S. except for our friends in Oregon. Talk about Practice Pro and claims prevention, as I said, questions at the end. Now, first of all, if you haven't figured out, I'm from Canada, have a bit of a different accent than you, and there are loads of ways that our different countries are different and loads of ways that they are similar. One of the ways that they are extraordinarily similar is malpractice claims. I have been at LawPro since 2001. I wore a claims prevention hat for my first 12 years here. I have dealt with all of the other insurers across Canada and indeed through NABRICO, the National Association of Bar-Related Insurance Companies, with insurance colleagues at the bar-affiliated insurers across the U.S. And I can say universally malpractice claims happen for the same reasons in our respective countries. The proportions vary slightly in different places. For example, if title insurance or title companies have displaced real estate lawyers, you don't see real estate claims. But universally, the causes of the claims are the same across the country. I'm very familiar with the ABA LPL Standing Committee's profile on claims, and I think it gives some useful sights into the claims in the U.S. I think its shortcomings is it only presents the claims from a select group of insurers, and it has very good representation at the very large insurer level and at the smaller insurer level. Little less so in the middle, and certainly doesn't tell you anything about the mistakes that are happening for those that are uninsured, which in some states are half the lawyers or more. Administrative note for today, all the figures I'm quoting are going to be in Canadian currency, and currently, right now, unfortunately, a Canadian dollar is only worth 76 cents US. It's rather expensive when we come over there for a vacation. Let's start out with some historical perspective. The Law Society of Upper Canada was incorporated way back in 1822. I think there were about 13 lawyers in the province back then, as it then was. It was incorporated to create a regulatory body for the legal profession, modeled after what had happened in the UK. Interesting side story, the first president of the Law Society was killed in a duel. The mandatory insurance requirement came to the Canadian jurisdictions in the early 70s. In part, the driver was, or a main part of the driver was public protection, a feeling that the public should be protected in the event their lawyer made a mistake. Part of the issue as well was making sure that reasonably priced insurance was available for lawyers. There has been, I will call it, an evolution of insurance in Ontario since the 70s. Initially, the Law Society outsourced the running of their insurance program to a commercial provider. It bounced around a couple of times to other commercial providers in pursuit of lower premiums, better claims management. It was then felt in the late 70s, early 80s, that the Law Society could manage it better on their own. They brought it in-house. Unfortunately, they did not a very good job of managing it. They ended up with about $200 million in unfunded claims liabilities due to a crashing real estate market. That led to the creation of LawPro. The unfunded liability is something that we look back and call the insurance crisis. And the task force that was created to look at that said there needed to be an insurance entity that operated separate and apart from the Law Society It needed to operate in a commercially reasonable manner. That is, the money coming in had to equal the money going out. It had to implement a system where the cost of insurance reflected the cost of claims, i.e., if you were a greater risk, you paid more, and that's what we call risk rating. I'll talk more about that in several slides. And then it had a marching orders that it had to resolve claims fairly and expeditiously, but it was not to be a no-fault compensation system. We had to take a principal approach to claims, and in some cases, coverage would be denied. So LawPro was incorporated in 1990. We are a full-fledged licensed and regulated insurance company. We are wholly owned by the regulator, the Law Society, but we are independent from them in that we have our own independent board of directors. It includes a majority of independent directors. There is representative on our board. 4 members of our board come from the treasurer, or from Convocation, which is the board of the Law Society. And the fundamental assumption in the case of Ontario is the Law Society is given a statutory right to have a mandatory universal program because of its protection, public protection duty. And there's similar logic in the other jurisdictions across Canada, although they don't all have mention of that in statute. Another reason we think it's essential to have mandatory insurance, whatever the form, is our statistics over years and years and years say that 4 out of 5 lawyers will have at least one claim during the course of their careers. I will talk more about the resolution of claims later on. There are slightly different structures amongst the insurers across Canada. We have one that's effectively a mutual. We have another one that's a reciprocal. There's one that's run as a department of the Law Society. The bottom line, though, is the policies that we all have are fairly similar. We've worked together over the years to try and make that happen. And the coverage is fairly similar. And in particular, we have the same limits across the country, exactly the same limits, except for Quebec. And what that essentially allows us to do is there's a formal agreement amongst all the jurisdictions in Canada. A lawyer can go to any other jurisdiction and practice with some restrictions, but can practice in another jurisdiction. It's the home insurance policy that responds. So that's something that is working out well. Let's talk now about the LawPro insurance program. It is the mandatory, what we call primary E&O program for 27,000 lawyers in Ontario in private practice. We only insure lawyers in private practice. There are actually 56,000 members of the Law Society, but only those that are in law firms or solos doing work for outside clients are insured. We have an optional excess program that covers in excess of the basic primary program. I'll talk more about it in a second. We also have our own title insurance product, which we actually sell nationally. And we have something called the Practice Pro Risk Management Program, which I'll talk about more towards the end of the presentation. Basic coverage under our basic coverage under our program is as follows. We cover attorneys, and in Ontario as well, the Law Society licenses 9,000 paralegals. If you are a licensed paralegal partner of a lawyer, attorney under our program, we insure you as well, and that's because we wanted to keep all the partners at a firm under the same policy. We have a specific definition of professional services under our policy. That, i.e., covers you if you're wearing your hat as an attorney giving legal advice, very narrow and specific coverage. Our coverage in Ontario and across the country is $1 million per claim, Canadian dollars, or $2 million in the aggregate, any number of claims on an annual basis. Right now, currently for this year and the same for next year, the base premium that we charge everyone for that coverage is $2,950 Canadian. The default deductible is $5,000. I'll talk more about some of the other options later on. Loads of information online about our policy if you want to dig deeper. The other coverages we offer, innocent party coverage, that covers the dishonest act of others. It's required for all but solo lawyers. It's optional for them. So that's to protect the client from dishonest acts of a partner of a lawyer. We have what we call REPCO, Real Estate Practice Upfront coverage. That's required for lawyers who cover real estate and effectively covers frauds on our electronic title system. We have enhanced coverage for bad check frauds. We rolled that out several years ago when lawyers were getting duped by those. We offer very limited cyber coverage. We're looking at expanding it. As I mentioned before, we have excess coverage above the primary program. It's on a firm basis, not an individual basis. On our primary program, individual lawyers are the named insured. On the excess program, the law firms are the named insureds. We offer $9 million in excess of the $1 million per claim coverage on our access program, and it is aimed at solo and small firm lawyers, basically firms of under 10, and that's because the bigger excess insurers would have no interest in them, and we felt a need to provide that. We've been doing that for 20 years, very successful, very popular program for us. More information on the coverage is again on our website. Our Law Pro policy does not cover advice or work with respect to U.S. or other foreign law. It's not a risk we understand and can underwrite, so we don't cover it. Interestingly enough, the BC policy does. I already mentioned the mobility provisions, and we also have a territorial provision. We're very concerned about a lawyer acting or doing work on an extended basis elsewhere, so there's a limit to only 10% of your work can be outside of the country. We include automatically coverage when you leave practice in a few different circumstances. First of all, automatic at no cost. Every lawyer that comes out of our program gets $250,000 of runoff coverage. That's not reinstated. It's a eroding limit intended to be for the rest of your life. We also offer runoff buy-up. That is, you can top it up to $500,000 or $1 million. And we also offer temporary coverage for temporary leaves of absence from practice, 2 years or up to 5 years for family or medical reasons. Again, and that's just a neat way that we offer better coverage to help people deal with the different circumstances that come up. I mentioned risk rating. There's a number of ways we do that. Let me run through all of them. It's accomplished in a bunch of different ways. Base premium adjustments, optional coverages, premium reductions, what we call transaction levies, different deductibles, claim surcharge levies, and the REPCO coverage. Let me run through these in a bit more detail. I mentioned the base premium, $2,950. You can get, under some circumstances, a reduction in your base premium. Part-time lawyers, we offer a half premium. There's a cap on billable hours and a billings threshold for that. A restricted area of practice discount. Right now, if you practice solely criminal or immigration, you get a 50% discount in your premium. New calls for us have been traditionally a much lower claims risk, so we give them a 50, 40, 30, and 20% reduction, respectively, over their first 4 years in practice. And we also give the lawyers that work at what we call designated government agencies a 75% reduction in their premium. So these are lawyers that, say, work in a legal clinic setting or some of the other social service agencies that are run by the provincial government, but that do work in that environment for clients outside. It was important for us to offer those clients protection, as well as have those lawyers as lawyers servicing third-party clients under the umbrella of our program. We would like everybody under our program in Ontario that is providing services to clients. We also have something we call transaction levies. This is how we risk rate people for volume practices. If you do 500 real estate deals a year, you're a far different risk than someone does 50. So right now, it's $100 per litigation matter commenced. You throw an extra $100 in the pot, and $65 per real estate transaction. We run this on an honors-based system. Of the 100 or so million premium we collect in any given year, we collect $30 million of that by way of these transaction levies. For access to justice issues, we exempt family matters from the litigation transaction levy and other types of poverty law, kind of some tribunal matters and so forth. The $5,000 deductible is the default deductible under our program. That's triggered half when a statement of defense is filed, the other half when discoveries are commenced. You can also have a $0, $10, or $25,000 deductible with understandingly premium adjustment one way or the other to reflect that. As a practice influence tool, we use deductibles in two situations. First of all, there's a double deductible for conflicts of interest claims. They're always more complex, more costly in our experience to resolve, and there's usually two clients involved, so we do the double deductible there. We also had a problem with lawyers not paying attention on administrative dismissal types of matters, in particular not responding as appropriate when they discovered an error, so we instituted a $10,000 super deductible to get their attention and have them report more quickly to us on those because we felt we could do a better job repairing them. If you have a claim, your premium goes up, and that's what we call our claim surcharge levy. Basically, if there's a claim where there's an indemnity payment, your premium will have an additional $25 added to it for a 5-year period afterwards, $5,000 for 2 claims and more as you go up, and as you can see, the amount goes up progressively more. We see this as a way of, again, risk rating the practice, but also being a bit of a tool to encourage lawyers that have really bad claims records from getting out of practice. Although we had one personal injury lawyer who was running a factory who was paying us in round numbers almost $300,000 a year in premium. The most common errors, this is a key message here because it helps you better understand where clients are suffering damages from the work that lawyers do, and in our case, getting to see that perspective right across the profession, which most jurisdictions in the U.S. don't get to see. And this is a really important part of understanding why public protection is so important. Some background on the claims that we see: about 2,800 new claims in a given year. We have about 3,800 open claims files at any given time. As an insurance company, we're required to set aside reserves to fund those claims. Right now, that's about $375 million. We have about $100 million in claims costs in any given year. I will tell you more in a minute about how that is broken down. And we take a very principled approach to matters. If the lawyer clearly made an error, we will work to repair that matter and set the client right with some kind of offer to settle in terms of resolving it. And we will settle the claim. If it is really an unhappy client, a fee dispute, we don't make economic settlements. We won't throw money at those kinds of disputes to make them go away. General claims statistics: 101 claims per 1,000 lawyers per year. Looked at that number in a number of different jurisdictions. And it varies based on the definition of the claim and the claims environment, but that's ballpark, not an unreasonable number. Our experience is claims are reported on average 2 to 3 years after the services are provided. I will give you a graph with more details on that further on. Lawyers in the 6 to 25-year window are the ones with the most claims activity, and despite strong impressions otherwise, we see similar claims happening everywhere, and I will talk more about that further on. Global descriptions of loss. This is what we would call the global errors. Where do they happen? And if you take anything away today, this is the key slide of the presentation. 1/3 of lawyer-client communication relationship issues or errors involve 1/3 of our claims involve lawyer-client communication and relationship issues. About 19% time management. I'm going to tell you a little bit more about what each of these are in a minute. 18% are what we call inadequate investigation or discovery of fact, and that's a worrisome one. I will explain that more. Only 13% of the claims we see involve a failure to know or apply substantive law, and I'm going to bang the drum on this one. So much CLE focus on substantive law, and they're missing the boat. Clerical errors, 7%, conflicts of interest, 4%, frauds, 2%. And then I have wellness off here on the side. We don't often see or learn of direct evidence that there's a wellness issue, addiction, personal, finance, health matter involved. But afterwards, as the claim progresses, it's frequently a wellness issue in behind it, in particular if there are clusters of claims. And that's an important message from a claims prevention point of view. I will revisit that further on. Want to compare and contrast count of claims, which is this graph, versus the next graph, cost. And as you see, the proportions are fairly similar with three variations I like to note.
Hey, Dan,
Conflicts of
Dan?
interest. Yes.
Dan, this is Glenn Olson. I'm sorry about this. We're having technical difficulties on our end, and I know that these are fairly important slides. So are we likely to be able to iron them out so that we can see them? Okay, in about 30 seconds, we should have our slides up again. And I know you're kind of at the heart of the presentation. I just wanted to make sure that we didn't, blow by these.
Oh.
Yeah, this is very interesting to the committee. So I'm hopeful that we can get this up and displayed in just a second or two here, and we'll be able to go back to that slide.
Okay, I'm on the count slide now. So let me know when you're back up. I get to take a drink of water. This is good.
Yeah, there you go. You get a breath of air and a drink of water here while we get the visual up and running. Actually, Mark and I have some show tunes that we have prepared. If anyone's interested. Okay, Dan, we are up and running again.
All right. Again, the global descriptions of loss, as you'll see, the blue portion, lawyer-client communication, a third of errors, time management 19%, inadequate investigation, error of law, kind of moving on down. So the key points here are error of law, only 13%, practice management issues, client service issues are the bulk of the rest of the errors. That's the count aspect, which is important, but from our point of view, we also looked at the cost. Here, highlight, again, conflicts claims twice as expensive proportionally. Again, complex matters, typically two clients involved. Clerical errors, far less costly proportionally. We tend to be able to fix those. Fraud are proportionally more expensive there. The most common ethics complaints, a key point here, per capita for the Law Society, roughly the same 10% of lawyers in any given year, interestingly enough, so the same rate as the complaints. However, when we look at the types of complaints or the drivers of complaints, service issues, and on the next slide, I will give you a copy of these slides afterwards, but let's run through these. Service issues, these are the client communication things. Integrity are criminal and sexual misconduct. Financial is trust accounts and fees and all of those kinds of things. Governance is not following the ethics rules. Conflicts and special readmissions capacity and so on. I guess if you look at that, what's striking is some of the proportions, the service issues, the client communication, identical. There's a bunch of issues, though, on the ethics side that have nothing to do, rarely, if anything to do with malpractice claims. So that's an important contrast to keep in mind, because often on the regulator side, on the CLE side, there's a really huge focus on the ethics rules, less so of a focus on the real drivers of malpractice claims. I'm going to come back to that right towards the end of the presentation. The different types of malpractice errors, very, very quickly, let me run through what I mean by the different types so you're clear and you understand that. Three types of communications errors: failure to follow the client's instructions, failure to obtain consent or inform the client, or poor communication with the client. Often these errors at the end of the day end up being a he said, she said. Lawyer says one thing about what was said or done or not said or not done. Client says something other, and this is why documentation on files is so important. Time and calendaring errors, 4 types and 2 groups here. There's the strict deadline, the tickler, the limitation periods, failing to know the deadline, knowing it but not having it in your calendar, having it in the calendar or not reacting to it. And those are the deadline. And then the other side there are the soft deadline errors, the procrastination or lack of follow-up, not promising work or doing work on a a timely basis. Instructions are sent and no follow-up. So that's sending out the draft will and not following it. Those proportions change amongst different areas of the law. I'll talk a little bit more about that as we go on. Inadequate discovery or investigation of fact. This is a combination of a client communication and a lawyer legal services aspect, and we break it out separately. The really big concern here is this error has doubled in the last 15 years, and it is, I think, clearly a symptom of our new way of doing things. Quick text, quick answer, news bites and all. Clients demanding quick answers from their lawyers. Lawyers not taking the time to dig in and get all of the relevant facts to give the lawyer proper advice. Sometimes pressure from the client to keep the fees down. That's an area of concern. Claims here we've seen growing. Substantive law, the law is far more complex, far more specialized than it was. 30 years ago, most lawyers were generalists. Today, we're mostly specialists, so you have to keep up on the law. We often see tax issues being very costly here, and dabblers are often the ones disproportionately that make errors to knowing or applying the law. And this is people usually out of good intentions that are stepping out to help a family or friend with a matter that's outside their area of law, and they get in trouble here. Client delegation errors, misfiled, lost documents, that kind of thing. Lack of supervision or poor delegation, and that's both respect to work within the office and delegated to somebody outside of the office. Conflicts of interest, two types, acting for more than one party, and that's or entity, that's the family, business, previous versus current clients, or where a lawyer acts where there's some self-interest when there's fees owing or investing in the clients. Our experience on conflicts, lawyers and law firm systems spot them, but the conflicts are ignored or try to be justified by trying to keep the client or try to please the client. Are big firms really that different? And yes, absolutely, in a million ways. The world of Wall Street is different than the world in a small firm in the rural U.S., sole practitioner. And when we look across firms of different sizes, and this is a confusing graph, but the point it makes is really striking, so I like to include it. So we look at types of claims by firm size. 6 different bars on the left, solos, firms 2 to 5, 6 to 10, 11 to 24, 25 to 74, and 75 and up by type of law. So the red is plaintiff litigation, so you'll see in the middle the litigation boutiques, more work done there. Corporate is the Navy, so more corporate at the big firms. Green is real estate, lots more real estate at the solos and smalls. Pink is family, a lot more family at the lower end. Wills and estates across the board. IP, much more at the kind of the big firm boutiques and so on. So very, very different focus in terms of types of law and very, very much what you would expect to see. However, when we look at the types of error by firm size, look at the consistency there. It's absolutely striking how consistency. It doesn't matter what size of firm you're at. Communication with clients, systems, etc., they break down in the same ways. The errors, the proportion of errors is roughly the same across all firm sizes. The cost of those errors is different. I will come back and explain that further on in the presentation. And a point of reference, here in Ontario, of the 27,000 lawyers we insure, 1/3 are solos, 1/3 are firms 2 to 10, and 1/3 are firms 11 or larger. Let me very quickly highlight how the profile of errors differs amongst different areas of law. Plaintiff litigation, the time management, 45% of errors. No surprises there. Conflicts of interest, very low. They seem to recognize and avoid conflicts. The profile for defense claims is almost exactly the same. Defense litigation, is almost exactly the same as the profile for our main portfolio, a bit higher in time management. Real estate claims, client communication, higher than the 1/3. Here, difficult, complex manners, unsophisticated clients. So we see things falling down there. Inadequate investigation, much higher. Again, you still got to do work and the searches and all on real estate matters, so that's much higher there. Corporate law, surprisingly to most, communications also proportionately higher. Here, I think the issue, again, complex matters, and often in the corporate environment, you're dealing with different individuals on the corporate side, so more opportunity for confusion there. And law a bit higher, conflicts much higher here. Corporate lawyers often get themselves in trouble on the conflict side of things. It's the worst area for conflicts. Family law, communications higher again. Emotional clients, complex issues. Law is also higher here. We have provincial law, federal law, keeping up with the case law. So that would explain that. Wills and estates, inadequate investigation here. Again, you've got to do some homework to write a will properly, catch all the assets for a client. I spend an hour sometimes on those last 6 slides, or even longer with a specialized bar. If you visit our website, there are what we call our claims fact sheets that will give you a lot more information about those different specific areas of law, the types of errors, and advice on how to avoid them if you're wanting to dig deeper there. Another really bad complex graph for a PowerPoint presentation, but it makes a key and fairly simple point. It takes different periods of time for claims to arise. So under 10 years is the blue line. The green line is over 15 years. So at the very top, you'll see wills and estates and real estate. A larger proportion, a much larger proportion of claims take more than 15 years to come up. And you'll see in the little square boxes down there the length of time for the longest claim to come up. So an amazing 56 years after a real estate deal there. So some interesting perspective there. Other drivers of claims, again, I mentioned, frequently we find out afterwards, lawyers with personal or health issues, something else was going on, and that's the reason that lawyer wellness programs are so important, getting people help before they really fall off the rails and get in more trouble. Cyber-related claims, in particular, recently the bad check frauds and funds redirection. We've got loads of information on preventing that. And we do point out to our insureds, suing a client for fees almost always results in an allegation of negligence coming back at you. We say don't sue for fees unless you're very careful and confident you've done all your homework. Resolution of claims. Talked about this earlier. When we look across our portfolio, 45% of our claims are dealt with without any costs whatsoever, and these are the unhappy clients and fee dispute matters. 41% are dealt with defense costs only. That is us hiring outside counsel to manage litigation. We do very limited litigation in-house at LawPro, and 14% ultimately involve an indemnity payment. I will point out that's the global profile for our portfolio. We were looking at this for the very largest firms, so the 30 or so firms in Ontario that are 75 or more lawyers. The claims that would involve an indemnity payment for them would be in the order of 3 or 4% of the claims they reported. A much higher proportion would have no cost whatsoever. So the first thing that may come to mind is, okay, fewer claims involving indemnity, they should pay lower premiums. Sorry, no. When we look at the average cost of a claim across firms by firm size, the value of claims go up at the bigger firms, and the average cost per claim is actually remarkably consistent across all firm sizes. In terms of distribution of loss, very important for us as well. Count is one thing, cost is another. When we look across our claims portfolio over an extended time, only 4% of claims go over $250,000. However, that little 4% by count piece of the pie costs us 44% of our overall dollars. The lesson there being relatively few large claims can be very costly, and our numbers change in any given year. You know, if we have 10 limits claims of $1 million versus 15 or 18 limits claims, that can have a big impact on our bottom line. Wanted to talk risk management and claims prevention. When Law Pro was started, shortly thereafter, we launched Practice Pro, a claims prevention program. There was a stipulation when it was formed that no more than 2.5% of our premium volumes could be spent on this, but it was seen as a very important task. And the logic here, quite simply, is that a fence at the top of the hill is better than an ambulance at the bottom of the hill. Doing work to help lawyers recognize more proactively where claims happen, why they happen, giving them resources to help them avoid claims is better than mopping up afterwards when there is a claim. So Practice Pro puts loads of resources up on our website available to lawyers. PracticePro.ca is the website. And my take from day one, and that was my first job here at Law Pro, was running that program. Everything we put up is in front of a wall. There's no passwords protecting it. I don't want lawyers scared away from looking at a resource, accessing a resource by a wall. So you're free and able to look at everything. We focus in back to that graph I showed you, lawyer-client communication relationship, and all sorts of articles and advice and checklists on controlling client expectations, making sure they know from the start the process they're going to go through, the time it's going to take, the costs, and the results, and not to sugarcoat any of things. Practice and file management, calendaring, conflicts checking, and the importance of documenting the file, having retainers, sending reporting letters, keeping the client informed. And we have checklists on drafting documents. We have sample retainers for a whole bunch of different areas of law. We have sample reporting letters and so on. And again, we get out wherever we can to make those available to lawyers, talking to them where claims happen, why they happen, and what they can do to avoid them. And that leads me to CLE prevention. We believe...
Hi, Glenn Olson. I think we're getting fairly close to the end here, and this is actually this is fabulous, and particularly the CLE and the risk management piece. But I wanted to make sure that we leave some time for questions, and I wanted to kind of structure some questions around a couple of themes that we've heard today, if you don't mind.
Okay, I guess if I could have 5 minutes to finish up, and I think I'm going to address some of the questions that you threw my way, and that may help prime the discussion.
Okay, yeah, I think that makes good sense. But I did want to ask you some questions about kind of the motivation and the structure of your program and the feedback that you're getting from your lawyers as to how the program is operating. And those are some themes I wanted to make sure that we hit.
I will touch on some of those in the next. I will go as fast as I can.
Okay, no, I don't mean to speed you up, but that sounds great. Thank you.
Understood. So we believe that CLE has a role in claims prevention, again, thinking beyond substantive law. And actually, as a tool to shape CLE, we have a risk management credit that sees lawyers get a $50 premium credit for attending at an approved program. And we look at programs offered by other people. We approved 265 programs. We had 50,000 lawyers at those. So we see that as putting our agenda out there. And we see risk management, it's not just substantive law, it's ethics, procedural, the soft skills, all those law practice management things which aren't even given CLE credit in some jurisdictions. And we see agendas like this that have absolutely nothing about client communication and expectations and all. So I'd like to see that fixed. And there's just a whole example here, and this mirrors on the risk management advice. And again, I won't go through these and I think you'll have the point, you'll recognize the points that they make. So my closing thoughts, clients should be compensated if an attorney makes an error, and it's important that all attorneys have access to insurance. And the captive program offers a number of benefits. It lets us develop an expertise and focus. We see the whole claims picture and we respond. It gives us the ability to shape case law, and it also gives us the resources to put together a claims prevention program. The risk management budget at Law Pro is about 1.5% of the premiums that come in. We have a general expense ratio, that is the cost of running the company, in the low 20s. Other typical small insurance companies, it's up around 30, and again, that's because we have the expertise. We have a very much lower return on equity because basically we're a not-for-profit insurance company, and there's no broker involved. That shaves 15% or more off the top of the premium. That all means low premiums. Other things that will come up if you're setting up a captive: the insurer needs to be independent from the regulator. There needs to be a wall between the two so that claims information and complaints information is not shared. And hint, lawyers with complaints will be known and on the radar of the Law Society far before they're on the radar of the insurer. Regulators always want but can't have the money that insurers put aside for claims, and attorneys always want everything covered and lowest possible premiums. You should be careful with comparisons. Yes, there are loads of similarities with our different jurisdictions, but legal ecosystems are different. The way legal aid is funded, insurance, and so on. In particular, take a lesson, look at some of the lessons that are happening with respect to the difficulties in the UK, where commercial insurers have come in and they've gone out and they've left a lot of lawyers high and dry. I'll come back to you now, Glenn, and let you answer some of your questions. I think the other points that I would cover off would just be wrap up.
There we go. Yeah, thank you very much, Dan. This is very, very helpful, and it's really useful to get a good sense of kind of how your program is structured. And let me just hit on a couple of themes that we have kind of discussed today. One is the alternatives to mandating insurance, for instance, having a captive program. And I guess my first question is whether in Canada the provinces or the provincial programs have considered other models like requiring disclosure when people don't have insurance, or mandating that there be insurance purchased in the open market. And I realize you have a very long-standing program, but I wonder whether those are themes that have come up in discussion, in people who are considering the program.
No, those themes came up in the distant past. And what the concern is, and we went through an evolution here. We didn't have the expertise or the money or the capital in the early days to set up and insure. The other provinces went through a kind of similar evolution. So we went out to a commercial provider, and the feeling initially was it was good and it was reasonably priced, but then the feeling was the premium went up too high, and so they went to another commercial provider who offered a lower premium, and that went along for a while. Then they felt they could bring it in-house, and that worked out until they figured there was something more than having a few dinners from a committee that wasn't really managing an insurance claims operation properly. So there was an evolution here, and I think you will find in Australia they did exactly the same thing. They had exactly the same conversation. The evolution over the last 30 years there with their mandatory programs has been the same. Insurers, and my guess, if I made a prediction, what will happen with you, if you go that far in terms of a mandatory, it'll be, there's only one or two commercial providers that could do the whole shebang, so you'll open it up to a bunch of commercial providers. They will come in and it will be competitive and they will offer lower fees, but they have to play the claims, so eventually the money coming in has to equal the money going out, and you go through hard and soft cycles when it comes to insurance. When there's loads of capital out there and people see a perception that they can make money, they will come in and they will set up an insurance company. When there's perception that they can make money elsewhere or they have a very bad loss experience, they pick up and they leave, and that's the exact situation in the UK. In early days, there was discussion about notice to the client of insurance and the amounts and all, but we've got away from that by having standard programs everywhere across the country. I'm just hearing static. Are you still there?
Check, check.
I'm just hearing static. Are you still there? Hello?
How about that? Can you hear me?
I can hear you now.
Oh, good. Okay. Just a little bit of technical difficulty there. We've heard that, one pushback that you can get from the solo and small firm community is just about cost. But I realize that your program provides an awful lot to the solo and small, firm practitioner. Is there any pushback on cost in Canada that people say this is just too high a premium, or could I be in a different market that would, offer me something that's less expensive?
Yeah, we do hear complaints from time to time. It is relatively rare, notwithstanding the similar coverage limits across the country. I believe right now, in round numbers, the premiums vary from $1,100 to $4,000 a year. The premiums go up and down in the different jurisdictions, in particular smaller jurisdictions where one or a few large claims can mean a big impact. So yes, we do from time to time hear complaints. Most pretty much accept it. We do hear arguments from time to time from people who say, I only do small claims court law, how come I can't get a cheaper premium? But thankfully for us, the single base premium across the board, we think it's a very reasonable number. We score points with lawyers with all of our risk management. And as well, we do, after claims are handled, kind of standard surveys. How do you like what we did? How did we do? What could we do better? How did you like our outside defense counsel? And we get typically 90-95% or a better kind of strong thumbs up on the work that we do with people there. I think relative to the Law Society, whose fees are actually less than ours, the work and resources, the support that we've given them over the years, we have a bit of a more positive relationship with members of the profession than the Law Society does. There is more squawking about their fees than our premiums, I think it would be fair to say.
Dan, can you hear me? This is Heather Rosing.
How are you?
Good. Thank you so much for being here today. I was trying to count up how many times I've heard this great presentation. I think this is my 7th time, and I'm totally honest when I say it's just as interesting every time I hear it. So thank you so much for being with us today. And I'd like to get your opinion on the scaling issue. We have a lot of attorneys in California, over 200,000, and I'm just curious, and nobody in Canada or the U.S. has done what you're doing on our scale. And I'm just wondering your thoughts about scaling your model or the Oregon model or a similar model to the scale of California, what that would look like if it's possible, what the challenges would be. Just a small question, Dana, really narrow one.
All right. Well, my knowledge of your financial regulation is fairly limited. I think what we do could easily be scaled up. My guess is the real practical issue for you would be coming up with that initial capital contribution to create an insurer. That would be a tall order. You would almost have, as we did to get out of the insurance crisis and to capitalize ourselves, there was a special levy of $9,600 on every lawyer in the province. And again, we were in a crisis mode, and that's what was determined was necessary to do or to start things up. And I am darn sure that you would hear great complaints from your lawyers if you were to try to do something like that to set up a mandatory captive insurer. Like an organization like ALPS, which is a multi-state insurer, they would have quite possibly the financial wherewithal to come in and set up a captive program for you from a single provider. I suppose the other thing you could do is approach multiple commercial providers and have some sort of affiliation or designation. The problem with that, and this is a repeated problem that is seen in jurisdictions where commercial providers are out there, is they will do detailed underwriting by types of practice, by firm size, and so on, and you will end up with lawyers who are unable to find a commercial insurer that will give them coverage at a reasonable rate. And I believe Iowa, which opened up their program, I think set it up so that there are several different commercial providers there, but there is somebody that is agreed, and I believe it's ALPS, to be the insurer of last resort. So that somebody who can't otherwise get insurance has a place to go to get it. By opening it up to the commercial market like that, effectively you make the insurer the gatekeeper of who can practice by a lawyer's ability to get insurance or not.
Hey, Dan, this is Randy Miller. I had a question. I don't think you were around at the inception of these programs, so maybe it's more of a rhetorical question, but if we were to start a captive program here in California, would there be a load on the program for the recidivist lawyers, the bad drivers that have multiple claims, or does everybody start with a clean slate when you start? Obviously, as the program builds, you can start surcharging the bad drivers and raise more money in the program for it to be actuarially sound. But do you have a thought on that as to day one?
I think day one you have to go with a fresh start to try and bring all of those past claims in. Who knows what those costs might be? You would need a massive amount of capital to cover them off. So, absolutely, a fresh start would be the way to go. It would be up to people, to the extent that they already had insurance with other carriers, to get tail coverage from those carriers if they were so inclined, and otherwise those without insurance, I think you would have to start afresh from day one.
I guess you sort of have a paradigm for that, because if I moved to Canada tomorrow and wanted to get licensed and practice law there, would I import my Did you get the end of that, Dan?
You cut out at import your claims.
The question was, would I import my claims history to the Canada program, or would I start with a clean slate?
Okay. A huge oversight on my part. One key aspect of the structure of our policy that I didn't mention, we have a claims-made policy in Ontario, and it's the same for all the other insurers across the country. So it is the policy in place when the claim is made or comes to be discovered that responds to the claim, not the policy that would have been in place back when the work was done. So if I had a claim today that arose from work that I did 5 years ago, the policy that I have in place now would respond to that. So if you were a new lawyer coming in, I believe what we would do at coming into the jurisdiction, you would have a fresh start. We would not cover work that you had done previously outside the jurisdiction. So that there would be a fresh start from that point of view. But the magic of having a claims-made policy like we do is critical for when lawyers jump firms. It makes it far easier for lawyers to jump firms because it's the new policy or the current policy in place that would respond to claims, and at least at the primary level, that's there. If you jump to a new firm and you have a claim surcharge levy you're still paying off, it would be payable by the new firm. What you do at the excess level is up to you and the contractual arrangements at the excess level. It also allows us to offer the free $250,000 tail coverage.
Can I jump in with a question, Randy?
Yeah, go ahead, Ruben.
Dan, this is Ruben Duran. Do I recall correctly that you said the surcharges and the levies are administered on an honor basis? In other words, self-reporting?
The transaction levies are on an honor basis. The claim surcharge levies, you would get, our policy runs January to end of December. Our invoices for the following year's policy go out in October. If you owe us a claim surcharge levy, that would be on the invoice that would go out with your premium invoice for next year.
One last question, and then we've got to move along to our next speaker.
Right, we'll take one more question. Lisa?
Yeah, Lisa.
This is a really quick one. What happens if they default on their premium? Are they just suspended from practice?
We have a unfortunately long and laborious process of sending them about 1,000 letters, and then we can ultimately refer them over to the Law Society, and there's a suspension administrative process that they are suspended for not paying premiums, and we can do the same for not paying deductibles and so on.
Great. Well, I think that's our last question. And Dan, we wanted to thank you very much for spending time with us today. This was super helpful, and you've got a great program up there. So thanks again.
Thank you. Great to have an opportunity to brag about it a little bit. I would be pleased to answer any further questions that people have afterwards, or comment on a draft of your reports. Again, all of our information is online, and I would recommend to the committee, if you want a clear picture of where the future of legal services is going, I encourage you to read The Future of the Professions by Richard Susskind and Daniel Susskind. Nothing I have read paints a clearer picture of where the profession will go, how technology will impact and take away the legal monopoly, and I encourage everybody to read that. Thank you. Again, wish I could have been there today, but committee meetings here prevented that. Best of luck with the rest of your presentations and deliberations.
Great. Thank you so much, Dan.
Thanks, Dan. And don't sell yourself short. Canada gave us Neil Young and Justin Bieber. So
yeah,
that's the good things we like about you.
All right.
Yeah.
Have a great day. Thank you.
All right. Thanks so much. So I think, I don't know if you want to take a short break, or we can move in with our next speaker, if whatever your pleasure is, Randy.
I think we'll get Mr. Clappin on, because I know he's here.
Yeah.
Right? We've got a live speaker, and I know we've been waiting for a while. I just feel like we should take a break and turn into something longer, and I don't want to put our public on. There you go. So I knew you'd be
Come to the right place.
Yeah, there you go. So let me introduce Courtney Claflin. He's the Executive Director of Captive Programs for the University of California, the Office of the President. And I'm going to have him describe a little bit, the programs that he administers, and really actually the programs that he's created for the University of California system that are along the lines of the of captives. He's got more than 30 years of experience in the insurance brokerage community. I think you were a direct writing agent, right? And also an independent broker, and you ultimately became an expert in the complexities of captive insurance. And it's kind of interesting. We've been talking about captive insurance all day long. I think it's probably about time to define it. And I thought you're the guy to do it. So if maybe we could start, Courtney, if you could describe the programs that you've kind of created for UC.
Yeah, we have a 4 captive portfolio right now. We've got Fiat Lux Risk and Insurance Company that was established in 2012. I came to the university in 2015 because there was nobody running it, and it was a small captive. about $25 million captive doing a couple of things. I've built 17, 18 captives now, and so I came out to help UC broaden it. Right now, that's over $1 billion captive. We've got probably close to 40 coverages in there. We do quota shares with our reinsurance companies. So when you buy limits in London and Bermuda, you buy them in blocks of 10 million and then 25 million and then 50 million and 100 million and so on until you finish out your tower. And in each side one of those blocks, you'll have multiple syndicates, each taking a percentage. And so what I do is take Fiat Lux and I play as a percentage player alongside the syndicates wherever I'm needed. I'm here to help. I'm not here to cause problems. We also provide layers and buffers. So this year, we had a reinsurer pull out on one of our lines of coverage in a $5 million layer. So oh, is it timed? Okay.
Yeah.
Yeah, well, I'll blow the time limits, that's for sure. But we lost a $5 million layer, and so I stepped up and provided a buffer layer for that. We also provide reinsurance directly to the second captive I built, UC Health RRG. That is a reciprocal risk retention group with which to sell medical malpractice insurance to physician and physician groups that are affiliated with the University of California system. We train half the docs in California in our 6 medical schools, and they get out. And if they don't join our 15,000 employed physicians, some of them come knocking on the door and say, hey, can you help us with this? So I built that my first year here. And then we just tilted up Eureka and Eureka One, which is a cell captive structure. We're Fiat Lux Risk and Insurance Company is a not-for-profit company, and the IRS you will lose your nonprofit status if you have too much third-party business. We're going to self-insure our employee life insurance, and that's about a $60 million a year spend. So that required us to build a new captive. So we built a cell captive structure, and Eureka would be called the core company. It can be risk-bearing or non-risk-bearing. We chose to make it a non-risk-bearing captive. And it sponsored Eureka One, which is an incorporated cell captive, and that's where we'll put the life insurance. California State University came to us and said, hey, can you do it for us too? So we're helping them build and sponsor their own captive so they can do what we're doing. And then we have other third parties, whether it be JPAs, school districts, et cetera, that are interested in doing this simply because it's a more efficient way to finance the risk.
Can you explain what you mean by risk retention group and a non-risk-bearing captive? The different structures that you're talking about?
Good question. We're incorporated in DC because in the state of California, you can't set a captive up here. They do not have captive legislation. So if you're going to build like UC Health RRG, that's a reciprocal risk retention group. When we built that, you want to have certain cornerstones in order because now we're out on the streets and technically competing with traditional carriers. Now, our intention is not to be a commercial carrier. Our intention is to be an accommodation to our med centers and to provide a product to affiliated physician and physician groups. So when you're going to build a captive, all the captives I built, you build them to be better than what's on the street. And so we built that, and one of the key components there is that every physician insured is an owner. And every owner, conversely, is an insured. So they have access to the underwriting profits and investment income that the insurance company has. Now,
Is that like a mutual?
Yeah, but you're going to be hard pressed to find mutuals that pay dividends. They call themselves mutuals, but it's not like they're spitting out a lot of checks all the time. But yeah, and in this case, in a reciprocal risk retention group, you have a voice at the boardroom level, as opposed to a mutual. You're not going to get invited to the mutual because every insured inside that risk retention group is an owner. And we have Class A owners and Class B owners. Then the cell captive, that top box called Eureka is the core company, and it can bear risk, meaning it can provide insurance or it can choose not to. And what we've done is we've chose not to. We're putting that there as the sponsoring entity under captive regulations for cell captive in the District of Columbia, so that the whole idea behind a cell captive is you can spin off incorporated, legally, financially, managerially segregated insurance companies, where if one goes bad, you can't go to the other ones and say, give me your money, because I went bad. You can't do that in this kind of a structure. So in order for us to enable additional captive insurance companies, it's much more efficient in a cell captive structure than it is building Fiat Lux as a standalone. It's more financially efficient, it's more regulatory efficient, and it's quicker. Yes?
Can I stop you for 1 second?
Yep.
I'm Connie Broussard, and I had a law professor who said that if lawyers could understand numbers, we'd all have all gone to business school instead. And I know you're not actually talking about numbers, but I feel like you are, because I'm like one of the few people in this room who's not in the insurance business. So
Okay.
could you just like start at the very beginning about what captive is?
Sure.
So
That's
just,
a good point.
On the big jump that we recommend that we should do a captive insurance program, that the state should do a captive insurance program, like just sort of, what does that mean?
Well, that's an excellent question. A captive insurance company is a licensed and regulated insurance company whose ownership are normally the primary beneficiaries of the underwriting results of the company. Okay? So that means...
You got that, right? Sort of.
Yeah.
I actually just Googled the like a really quick definition
Uh-huh.
you were talking, but it didn't help that much.
Yeah.
All right.
Yeah, and you know what, Courtney, I think your point is a very good one. Just kind of taking a step back, what we've heard today are essentially what are, I guess you could call them insurance companies in Ontario and in the Oregon PLF, but really they're governmental entities that are essentially running the program and taking the expense and paying the claims and all of that. So that's one model, and then to Connie's point, the next model would be a captive insurance company, and what does it mean? And then what are the various kind of structures that you could adopt? And what would be the advantage of a captive over that governmental program? That's a lot to chew on.
Yeah.
But
Well, the thing is, just think of, everybody knows Travelers Insurance. Everybody knows State Farm Insurance. A captive's no different than those. It's a licensed, regulated insurance company. The reasons that it gets kind of confusing and they're called captive because they're usually built by the owner. So large organizations, instead of buying insurance off the street and paying all the margin and all the profits go to the insurance company, they choose to form their own insurance company because, number one, they can control it more. They can control the activity and the pricing and the service. And number two, think of this. You're with State Farm Insurance and you've been there 20 years and you pay $3,000 a year. You've paid $60,000 in claims. You're accident free. Your house hasn't burned down. Nobody slipped and fell on your front stoop and sued you. Where's the profit? The profit is sitting with State Farm. And so with captive insurance companies, what you're looking for is you're looking for the profit that your insurance premiums roll off. That's one reason. Another reason you form a captive is if insurance for your particular risk is not available in the commercial marketplace, or if it's too expensive. Because if you take a look at insurance is the purest form of socialism. The haves subsidize the have-nots. Okay, if you're a high performer, that stings. And so people opt out of that by forming their own insurance company, either as, if they're large and diverse enough, forming it by themselves, like us, or they can form a group captive, There's hundreds of group captives for ABC Manufacturing Company, Johnson's Plumbing and Heating, Ace Hardwares. These are entities that come together for all of those reasons to form their own insurance company. It's called a group captive. Fiat Lux sitting over there is called a single parent captive because we're big enough to build our own. Eureka, that is called a cell captive structure. As insurance agents, I built an agency captive where our insurance agency owned the captive. And then I went to our insurance companies that we placed business with as an insurance agent and said, hey, you give me 40% of the premiums from this book of business, I'll pay 40% of the claims. And then I get 40% of the profits. So captives come in many shapes and sizes. Captives have been around, there's some debate as the form of the first captive, but for over 100 years. And it was a group of textile merchants on the East Coast that couldn't get fire insurance. They had to form their own insurance company, and now that's called FM Global, which is one of the largest commercial insurance companies doing business in the United States right now.
Courtney, can I jump in with
Yes,
sort
sir.
of along the same theme? And I think I understand what you're saying. So I work for a firm that represents public entities.
Yep.
And what I hear you describing is what I know as a risk pool. So like it's a joint powers authority, a governmental entity where several like-minded governmental entities get together and pool their resources to provide their own quote-unquote insurance, but really they're just a risk pool, and your premiums vary based on your claims. Is that?
Yep.
Okay.
It's very similar in construct, although you take a JPA one step farther and now you're a licensed and regulated insurance company, which means if you want to, you can sell insurance.
Okay.
JPAs are almost like a holding cell and a group purchasing arrangement.
Right.
And to be honest with you, I'm a Minnesota kid, right? Grew up in North Dakota. I'm a hockey player. So JPAs are pretty unique to California. You just don't see JPAs all over the country. But it's a unique, like Cal State, they're in a JPA. But when you go through the finance piece of this, the JPA is if you do the same things in a captive that you do in a JPA, the interest income delta is triple because of all the restrictions on the JPA. You can be much more entrepreneurial with your investment portfolio in a captive. And so there's a lot of JPAs like Cal State saying, hey, I got the same money, I got the same risk, I got the same premiums, but I'll have the captive reinsure the JPA. So the JPA throws their claim funds into the captive, and now you're getting 4.5%, 5% interest instead of maybe 20 basis points in the JPA. Yes, sir.
So let's relate this to our little issue here. So we've got, you may get some sense of this, or maybe from being a state employee, we've got about 250,000 members, maybe 200,000 active members, maybe a little bit less. And one of the things that we're considering is to create a captive fund or captive insurance that would insure them for their risks in providing legal services. So the first question is, in what form of the various captive models that you just mentioned would that take? And then I'll wait on that because I have some follow-up questions.
Probably a single parent captive.
Okay.
If you wanted to make an impact in the commercial marketplace, you'd make it a reciprocal because then they get the profits. Otherwise, you're just another commercial carrier. And if you're going to build a captive to go into the business, you're going to compete with everybody that's in the business. Okay, is there a crisis?
No.
Okay. No. Then if there's not a crisis, who are you trying to serve?
Well, ultimately, we're trying to build a program that protects the public. There are others that will be served by this, lawyers that are insured and legislature will make happy because we protected the public. So I think there's a number of beneficiaries of it. Haven't really considered the profit piece. I don't know that that's would be a reason for building a program like this, but I leave that to the greater fiscal minds.
Can I ask a follow-up to that, Randy?
Yeah.
So let's say we're in a single captive parent world. That's the way that we would want to construct this. Let's say of the 250,000 lawyers, we're going to insure 150,000 perhaps, given exemptions and all of that. If you build it as a captive, you're going to be subject to insurance regulations somewhere, right?
Yes, in the domicile that you set it up, which would not be California.
Yeah, so if it's, and I think you were saying the favorable domicile would be Washington, D.C. or Delaware.
Right now there's about 30, well, depending upon what time it is and what day it is of the week, there's about 38 jurisdictions, 38 states. We're seeing a lot of states getting into it just for the money, for the tax and the fees. In theory, there's probably 4 U.S. domiciles that are head and shoulders over the rest.
So in the grand scheme of things, if you could build the single parent captive in a way, well, it wouldn't be a captive, it would be a government.
Well, the first thing that you think about when you build a captive is there a need for coverage? Well, the answer here is no. You've got a robust commercial marketplace with well-heeled and very reputable insurance companies. Remember the stuff you and I went over when you were briefing me on this. The one thing, there's disadvantages to captives too, is you tilt up a captive to sell medical professional liability for lawyers, the first thing that's going to happen is the commercial carriers are going to cut their price in half. They're not going to let your business get off the ground. And so and it's happened to me on more than one occasion where I built captives to compete against the commercial marketplace. And their response, there was 50% ownership in these captives. Their response was to cut their price 50%. So the initial 35 companies that I brought in, they stayed in, they stuck with it. But to grow it, everybody, I'd walk into, it was a homogeneous captive. I'd walk into a prospect and I'd lay out the program and they'd say, that's fantastic. And I'd say, okay, you got 2 choices. Do it or just call your broker and tell them you're really seriously thinking to do it and they'll cut your price in half. That happened.
Well, that's if we launch it in a competitive marketplace.
That's correct.
If it monopolizes or it's mandatory and effectively monopolizes the entire marketplace, then your rating is totally different.
Right. You're in the business shoulder to shoulder with all these commercial carriers, and our business is the juice worth the squeeze. Is it worth it? Now, if you have uninsured lawyers that you're trying to migrate them from uninsured to insured, that's a different animal. You could, we talked about the Oregon model. Just say, you know what, we're going to provide the first $300,000 worth of coverage, and the commercial marketplace will immediately step in and they'll create a wrap to go around it. And then they can buy that here. But the commercial marketplace is going to respond. And so they're going to put out 300 plus their excess limits, and you're going to compete with them. Can it be done? Absolutely. I mean, you could build one of those in 90 days. You can have it done.
Well, I don't know that we would build it to provide capacity or to compete or even to make a profit. It would be to ensure that lawyers are accountable for their malpractice and that ultimately victims of that malpractice are compensated. And this is just one of the models that we're looking at that accomplishes that.
And that was actually my question too. I think it's along the same lines. You said earlier that one of the reasons to do it is if something is too expensive. And so earlier, I think you were probably here, there were some questions about if there was an attorney who it was just too expensive for them to be insured. Because of past claims, maybe their area of law or whatever, that it was just too expensive for them to get insured. Can you discuss that, like how that model would be if there was a captive program just for those like sort of uninsurable, for lack of a better term, attorneys? What would that look like?
It would, it'd look the same, okay, single parent or reciprocal. And you have to understand in the insurance business, we have what's called adverse selection, and that's what you're alluding to, is it's going to be, it would almost be the high risk program. And could you build a captive for that? Certainly you could. And say, hey, come one, come all. If you can't get it anywhere else, we'll provide it. Now, along with that, you've got to take a look at what are your statutory capital requirements going to be? Your feasibility is going to your feasibility study is going to detail what you're going to get in premium, what you're going to get in claims. And if you use up all your premium with claims, you're going to have more capital contribution. So this is something that if you're just building it for the high risk, then you got to take a good hard look at what is the appropriate premium for them. Their premiums are high for a reason because they have claims. And it'll take considerably more capital. There's two requirements for an insurance company, financial requirements. One, statutory capital. Okay, so for instance, Fiat Lux, in order to even start working on that, I got to put up $500,000. And that $500,000's got to be sitting there forever and ever and ever. Can't be touched because that's your statutory capital. The second thing you have to put up is collateral. And here's how that works, is that your captive is going to take X dollars of risk. As a young captive, you'll probably take the first $250,000 of the claim, and you'll buy reinsurance for the rest of it. Okay? So now you're going to go buy reinsurance, and that reinsurance is going to say, once you pay this many dollars in claims, we'll pay 100%. And they'll do it on a claim-by-claim basis, and you can also buy it on an annual basis. Well, there's a gap. There's going to be a gap between how much money you have to pay claims and where their attachment point is. And you got to fill that gap with collateral. And it'll come in the form of a letter of credit, New York Regulation 114 trust. That's what I'd do because it's way less expensive and it looks better on your books. But you're going to have these two financial components. And if you're always burning through that working layer, the money you have to pay that burn layer before reinsurance kicks in, you're going to continue to have to make capital contributions to your collateral account because it'll get called if you're building the high risk pool. Does that help?
I want to go back to one of the original questions that we were going to try and grapple with, which is, would it be possible to build a captive here in California for California licensed attorneys in private practice that's similar to the Oregon program, meaning that that's the only place that that's the only carrier that attorneys can buy insurance from, and they must have it in order to practice. It's mandatory. And they can go out and get, higher limits from, reinsurance from other carriers. So the question is, can we build a program in California that is mandatory for all attorneys? And it's the only program that they can buy insurance from for that initial limit, whether it's 250 or 300.
Yeah.
Okay. And, okay.
If it's support, yeah,
Okay.
you could.
All right. So three questions. A, how do we do it? B, what's the advantage of that program as opposed to an open market program that we have now that's not mandatory? And C, the third question would be cost to attorneys. Is there some way, any way now that we could guess estimate as to the cost per attorney if we had that program?
Okay. How you do it is the easy part, because you can build, like I said, you could build a captive in 90 days. You have a feasibility study, you hire service providers, you hire a captive management firm, you put together a business plan, you submit it to the regulators, they approve your submission, and they license your insurance company. So that's not hard. Secondly, if you say, if you make law now that says the first $300,000 of anybody's legal professional liability must come from the state of California, then you're gonna collect your current uninsureds, you're gonna collect your current insureds, and you're gonna have a pretty robust program. And then the commercial marketplace will say, what are we going to do? They'll provide excess cover over 300. And as a captive, you can choose to provide an option for them or choose not to. What was the third part of your question? How much is it going to cost?
The open market. Premiums are very different, and it depends on how long somebody's been a lawyer, what their claims history has been, what areas of law they practice, et cetera. But what we've heard is that a captive, because it generally supplies more activities, it does, education, risk management, et cetera, that it's more expensive than the captive is more expensive than the open market conditions. So the question is, based on your experience, would it be substantially more expensive, about the same, to have a captive as opposed to having an open market?
Well, that's a good question, and if you are, it's going to fail. So, I mean, yeah, if it's more expensive than the open market, why do it? I mean, it'll fail. But you're under the auspices of you're mandating that first 300 grand go through this, then you've got the market. Okay, one of the first things that you do when you build a captive, sorry, microphone, didn't mean to hit you. You can go pull all the filed rates from every carrier doing business in the state, and the rate's going to differ between practice specialties, just like physicians. My neurosurgeons, they're way more expensive than my GPs for obvious reasons. In the legal community, the same thing exists, and the gentleman that just put on the presentation, I think he spent a little time talking about different practices have higher levels. From a risk management and safety standpoint, you can choose to or choose not to provide risk management and safety. You can contract with outside third-party service providers to provide all of that service, because I presume your industry is like every other. There are specialty companies out there that provide you risk management and safety guidance and counsel for certain things. So maybe your captive contracts with them. Well, that's going to be a fee-based contract, and it becomes a percentage of the premium. So you're going to have a good baseline of what rate you should be paying, because all the commercial carriers in the state of California have filed rates. You just go pull them. and you see what they're charging, and you can deviate from those rates. You can charge more, you can charge less, based on the experience of the individual attorney. I would strongly urge you to underwrite and price appropriately.
Underwriting may not be a clear term.
By underwriting, I mean you take a look at their practice, take a look at their firm, take a look at their loss history, take a look at their specialty, take a look at their claim history, how long they've been in business, et cetera. And by underwriting and pricing appropriately, you're going to have a successful company. Because although there's also another old saying, there's not bad underwriting, there's bad pricing, but pricing comes from underwriting. And as long as you're diligent in that regard, you can have a successful company.
You know, it kind of embedded in, just to follow up on Mark's question, kind of embedded in this cost structure issue is, how do you staff this thing? Because if you listen to, for instance, Ontario or Oregon, you know, what they're doing is they're essentially staffing it with government employees, folks who are part of a program that are going to understand kind of what the risks are and be able to tailor risk management and CLE. And so that's one cost structure. Another one would be, and I think you've adopted this with some of your captives, right, where you can purchase that service out in the market. And then I think you get to a question of, if you have a program like we're considering, or you're looking at these issues, why would you outsource that? Because how are you different once you've done that from, you know, the commercial marketplace, which is competing to provide risk management services or competing to provide CLEs? So I don't know if you have any thoughts on that.
You'll mature into that.
Yeah.
Right out of the gate, no. I would advise against it. You want professionals that pay claims. So you hire a professional TPA. That's probably gonna come with, because now everybody's gonna get an insurance policy. Do you want it as a rated insurance policy? You probably don't have to if you don't want to, since you're mandating the coverage, but that's a question for research. Yeah, rated is, AM Best is a rating agency that rates insurance companies. And so you can either choose to be rated or not rated, depending upon what you're selling as a product. So Fiat Lux is not rated because I insure, we have 10 campuses and 5 med centers and 3 national labs and 280,000 W-2s. We got a lot of stuff. But I'm insuring mostly our stuff. Take a look at the risk retention group. Risk retention group doesn't need to be rated because there was an act of Congress back in the 80s during the medical malpractice crisis that said, everybody's bailing. We're going to let you set up this form of a captive called a risk retention group, and you don't need to be rated to sell insurance to third parties. You take a look at Eureka One, that's going to be the life insurance. Okay, I, as an employee of the University of California, Office of the President, I'm getting a Prudential life insurance policy because Eureka One is just going to reinsure Prudential. So when you're building this thing, normally you get the front and administration and claims in a package to start with. And as you mature as a program, as you mature as a captive, then you can say, we can do that piece, and you bring that piece in-house.
Yeah, I think that kind of highlights an interesting difference between where we are and where Oregon was when it started its program. If you're in a hard market and you don't have very many insureds to kind of start with, you probably can roll the dice, I guess, for want of a better term, in creating your own entity and managing your own claims and actually handling this thing all, you know, internally. If you're looking at something, and this is kind of what I hear you to say, that if you're looking at something as complex as what we're looking at, you ordinarily risk, you would look to the commercial market where you would hope that you could get those resources.
So to compare it against the open market, does it come down to you have extended costs from a third party?
In theory, yes. I mean, the expense accounts or the expense ratios of captives are far below commercial carriers. Main reason is profit. We're not building in 15% to net 10 and make a profit. So, and when you roll out a captive program, every captive program I've ever rolled out, you'll roll it out about the same price as what you're seeing on the street. And when you build up a surplus, then you can turn around and say, what are we going to do with the surplus? Are we going to lower rate? Are we going to add service? Are we going to add limits? What are we going to do with this? Do we return it to the membership? You know, I'm a firm believer. If you're in a captive insurance company, you got skin in the game. You don't treat it like, you know, your neighbor's car. Treat it like your own. And I love it when the insureds have the ability to get money back with good behavior. There's no bigger risk management tool out there, I don't think, than I get some of my money back if I have good behavior. And so if you want to design it to build in that kind of a profit sharing arrangement, not a bad idea. That goes a long way for risk management. But from a pure rate standpoint, you know, it shouldn't be any different at the onset. It shouldn't be any different than the commercial rates out there, because the commercial companies know what to charge. I mean, they compete against each other all the time, and there's a robust number of them in California that apparently during our discussion, because I didn't know anything about this before they walked into my office. Seems to me it's very healthy, very robust offering of companies, strong companies. They know what they're doing. They know how to price it.
Well, isn't one of the problems that a captive LPL program would take on all comers? So now we bring within that program the 30% of small and solo lawyer practitioners in California that were uninsured into the program. So it's all well and good to look at the current marketplace of insured lawyers, but now we're talking about taking this outlier group and bringing them to within the fold. How do you build an actuarially sound program with that unknown risk?
That's another really good question. Is the only way to build a good actuarial, a good feasibility study is data, data, data. And if you're going to mandate, let's just go down the mandate roll, which we can't do at the Office of the President because our campuses and med centers will tell us to go pound sand, but that's fine. If you're going to mandate, as part of the mandate, you can say, I need a 5-year loss history. I need information. You send out a questionnaire. And on this questionnaire, they tell you their practice, how long they've been in business, et cetera, blah, blah, blah. And they have to attach a 5-year claim history from their insurance companies.
Okay, so that would just go into the rating of the program to determine, you know, what risk you're taking on. That would just be data that the underwriter would look at to determine the sweet spot in charging premiums for that product.
That's exactly right, because the actuarial is going to tell you what your loss pick is, what you should expect for losses. And that's where you start to build up the pricing. And, you know, between that, you can establish what appropriate rate you should be charging, because in theory, you have expected losses plus operating expenses plus any ROI you want on your invested capital and collateral, if any, and there's your price. And if historically, if everybody repeats their behavior in the next 5 years, the same stuff's going to happen.
Or 15% of lawyers who have never had insurance before. So there isn't such a thing as a 5-year claim history. There's nothing. You're getting the 10 or 15% of insurance.
Unknowns.
Total on.
Well, you know, you can also have them submit a notarized statement of their claim activity. If they've ever been sued, have them notarize it.
But that would only be.
I don't know the answer to that, but that's the first thing that came to my mind is, hey, write it down and have somebody notarize it, because if you're lying, it's not going to be a good outcome.
Well, it's a great exercise to go through, because I think what we're talking about here through the formula that you just related to us is, determining how to analyze the risk inherent in this group of actors,
Yeah.
150,000 lawyers. If we were to then look at all that and then pick a number, Oregon picks $3,200 and Ontario has $2,950 per lawyer. Everybody pays that in. You sort of hope that that takes care of the overhead, the underwriting, the claims handling and expenses, and return on investment if that's a factor. So you hope you get it right. But that information wouldn't necessarily be used to then, under that model, wouldn't necessarily be used to rate individually each lawyer to say, okay, you're going to pay more. There's mechanics built in to the Canadian programs that are not built into the Oregon program that allow you to charge more over time if that lawyer is a bad actor. But the Oregon program, everybody gets the same number every single year. So the challenge at the beginning would be to look at this group of actors, rate that risk, and come up with an actuarially sound number to charge them to build a program that is sound and doesn't go insolvent. Or that one you have to go to the next year and say, sorry, we undersold it or underpriced this. Now we've got to double it or triple it, and then we'll all run for the border.
Yeah. You don't want to go back for a capital call from your insureds via rate increases. Yeah.
We
have a payment plan.
We're just about through with our time allotted for this segment, but what we're going to do next is take a short break, and then we'll get to public comment in a minute. But is there anything more for Courtney while we've got him? This has been a good discussion, because I think it's made us all think, and it's been really helpful to understand how it gets put together. You've obviously done that many, many times over, so we know it's not impossible. Anything else, though, for Courtney?
I just had one question.
Yeah.
The Oregon model, she made a point to say that they actually were not an insurance company. They were not under the regulations of insurance. They even had a separate glossary of terms and everything. Do you understand what she meant by that, and would that change anything as far as how much it would cost if we could get that same sort of dispensation in California?
Well, I wasn't here for her presentation.
So basically, it sounded like they just, they aren't acting somehow. And
They're
again,
not subject to the filed rate doctrine.
Thank you. Somebody who's actually in this business.
They're not subject to any of the normal regs, because they couldn't do that model if they were subject to insurance regulations. All the insurance regs.
So they just created an additional government program.
Right. Yep.
Owned and run by the government.
Yep.
Okay.
Yeah. Okay.
Well, I don't know anything about government programs other than I pay into them with tax money. And I do know that with any type of government organizations, you've got layers of and lots of boxes to check.
Yeah.
So I would presume to start out, do they have the expertise to do it? Or are they going to stumble along for a bit? But apparently Oregon's got the blueprint. How'd they do it?
I think you've never, for instance, considered doing something like that with Lux or the medical malpractice cases, right?
No.
Theirs is more like state fund, basically.
Yeah, Mark and I were talking about this as the state fund. If an insurance company becomes solvent, the state fund is there to
California Earthquake
Right. And then they have state funds on top of people's commercial insurance, property liability, work comp and stuff, that if your insurance company goes broke, the state has collected X amount of dollars or percent of every premium ever paid and put it into a fund to pay claims for insureds of companies that went insolvent. And so I have no experience in that, wouldn't even know where to start. But it sounds like Oregon went through the same kind of process as the state fund.
Okay. Thank you very much for the helpful answer. We appreciate it. Folks, why don't we now take about a 10-minute break or so. Before we break, just so I know, is there any member of the in our audience out there who wants to make a public comment? I want to just take a quick survey so I know how to go on time. I will have to restrict the time. I hope that works with you, but it's good to know how many want to speak first. We'll give you that opportunity, but I'm going to have to figure out the limit. Thank you, everybody. Back to you.
Thank you very much. So interesting.
Yeah, it's fun, isn't it?
I only deal with like normal. I mean, I deal with the London bar, and it's so.
Oh,
Yeah.
You know what? You guys don't have a cool bell to ring when the Titanic goes down.
Oh, and you know what? Me and my staff, there's 4 of us.
Yeah.
Thanks, Bart.
Very nice.
That was fabulous. Thank you.
We'll be back with you later today.
Just get them while they're still ineffective before you rewrite them again.
Yeah, and you're the more that I have heard about Oregon.
I kind of want to do some of these.
We really have the regulators there. We just don't get to do that. I've already warned the board that maybe.
Yeah, he's on my board.
Yeah, they're big into Miami, and all over the place. We're pretty big. They routinely, hit
Right.
So, yeah, exactly.
Yeah, Nathan is on, both Nathan and Janet and our chief legal.
I saw you walk by, and I thought, oh, I was in a meeting, and I was trying to look for him, and I should have texted you.
Yeah, he is. He's the world's nicest man. I know. He's going straight to heaven.
Yeah, I think so. But, yeah, Orange Theory. Orange Theory.
I will. He's my boss.
Oh, yeah, my dog knows that.
Well, I'll tune in. Oh, very popular. Oh, thanks. I appreciate it. Thanks for having me. Yeah. If you ever have any questions?
Oh, thank you. I appreciate it.
Yeah. They could probably fit all of them.
I'm an employee of the office.
Not here, not here.
Cal State. And so, and Peter Taylor, who's the board of trustees, he was the old CFO at UC that built Fiat.
Oh, okay.
And
Oh, yeah,
when he
no,
left,
exactly.
it just wasn't doing anything.
Right. It's, the new guys like to say what's in it for me, what's wrong.
Can you do it? So we're helping them. Correct. Because they have one person.
Well, I never thought that,
I've done massive.
All right, folks. All right, folks, let's get back to your seats. Start our last stretch here.
Testing. Testing.
You're good? Check, check. Okay. Thank you, folks. Everybody is back. We are live with Mr. Webmaster and our webcast, so we are ready to move into our next session. For those that are following it here or on the webcast, we're right now at the point where we are going to have public comment, and then the working group will have a discussion about the captive insurance or fund model, which we spent most of the day talking about. And we'll adjourn right around 4. Hopefully, but I want to make sure that we get adequate time for everybody to participate and make comment on the topic we talked about today. Just as a little bit of context, because I know we've been engaged in outreach on our working group for however long it's been since we started, and have encouraged all sorts of feedback and input from all sections of the community. And I just want to make sure that when we look at these issues from any perspective, that we understand that this today and the idea of mandatory insurance is just but one of the issues that we're looking at or been asked to look at by the legislature. The others, if you followed the legislation, deal with looking at disclosure. We had a great subcommittee and meeting on that. The adequacy of insurance was another issue that we've studied. So all of these are available online, and were part of the mandate that the legislature asked the state bar to look at, and the form of which was the creation of this committee. But that said, we encourage everybody to weigh in on this working group and beyond on any issue that you feel as though you either want some more information on or have a personal viewpoint. So with that, I counted 6 hands of the attendees here today that wanted to make a public comment. Because we have lots more wood to cut this afternoon, I need to restrict the time for your public comment, and I'm going to do so at 2 minutes, and I'll keep my stopwatch up here. That's probably fairly charitable, by the way, because I've been in city council and county council meetings where it's 30 seconds or it's 45 seconds, and literally you are cut off when you hit that point. But we do very, very much appreciate your attending today. Many of you have been here since early in the morning, and we appreciate your public participation and your interest in this topic. So I'm going to ask you one at a time to come up to the table, and we have hopefully a hot microphone there. This also will allow those that are following the webcast to hear your question or your comments. And I would ask you first to identify who you are, and then at that point, we'll start our 2-minute time period. So, sir, welcome.
Good afternoon. Armand Feliciano with the Property Casualty Insurers. We are a national trade insurance organization. We represent about 1,000 insurance companies nationwide, and we do have most of the carriers, malpractice carriers, in our trade organization doing business in California and out of California. So like we had a working group ourselves, looked at the preliminary recommendations. And so just our thoughts were initially, and I think we have more questions than anything at this point. There's concern about data. And I think we looked at the last agenda items for this group. Basic questions: how many uninsureds do we have in California? What does the world look like now today in California as far as people who can't get insurance? So for us, we would support the recommendation that the bar hire a professional survey company and get some more data on these issues, because there are some more questions than answers at this point for us. As far as the disclosure, the promotion of voluntary insurance companies, policies, self-assessment, obviously, I think those issues that we're all open to. We don't have a position per se on the mandatory insurance on the private market, because I think, again, it goes back to the data. But I can tell you on the captive insurance market issue, there is no support from our group on that issue. Number one, we believe it's a robust market. I think the gentleman before me mentioned that. And there's some functionalities there. People talked about Oregon. Sounds like an unregulated market. How do you reconcile that with Prop 103 here in California? I don't know how many insurance we have in this committee or this working group, but it's a regulatory market. It's a highly regulated market. You need to figure out Prop 103, how is that going to be done? And that's an initiative body of law. People seem to think it's an auto insurance, but it actually covers this line of insurance too.
Thank you very much for your comments. Good afternoon and welcome.
Good afternoon. My name is Cindy Aragon from Aragon Haas Insurance Brokers, Inc. I have been an LPL broker for 30 years and an insurance broker collectively for 40 years. And during the 30 years writing lawyers' professional liability, I've taken upon myself to put together a spreadsheet on the carriers that have come and gone in California, not surviving this market because it's extremely difficult to operate at a profit. I only know of 2 companies that have. Arch Product, the State Bar, they operate, the last I heard, at a 4% profit when they make a profit, which isn't annually, which isn't always, which isn't guaranteed, and the Lawyers Mutual product. Lawyers Mutual, I believe, can offset their losses with a large criminal defense program. The other carriers, and I have a list of 40 of them that have been able to survive maybe 2 to 3 years maximum, because the number of claims are just unexpected, and the value of the claims are generally unexpected. I also have data on the losses by county, and Los Angeles far outweighs any other county in California and in the United States. So to compare Oregon to Los Angeles would be very difficult. I could probably pull Oregon claims data as well and try to do an analysis, a comparison, but the only way that my carrier, and I've pulled every carrier's filing and created a rating matrix, and I can usually tell the carrier from the outset whether they're going to survive or not. I think I have a 95% prediction ratio. But with my own program that I designed, we're in our 4th year with literally no claims because we've eliminated a great deal of exposure. And if you don't limit that for yourself, you may be adversely selected against by just insuring the uninsurable elsewhere. Well, there is a forewarning.
Thank you very much. May I ask, did you submit written comments? No? Okay. I had a memory of seeing some of the information you talked about in some of the...
I have spreadsheet material. Anything that you need, I can submit.
So which way did that cut? What was your bottom line on captive is a good idea, mandatory is a good idea, captive's bad, mandatory's bad?
I think insurance is affordable. I think there are a lot of facilities out there. To be profitable, however, you would have to charge $10,000 per person for $1 million with full prior acts, which is what the State Bar charges and Lawyers Mutual charges. All the other carriers I go to charge about $4,500. That's why they're not profitable. That's why they lose money and they disappear within a couple of years. But there are so many companies because there's a lot of money in the industry to be attracted to. They come in, they try to survive, and they don't. But it benefits the public because they're half the rate of the State Bar. So if you want to be profitable, follow the State Bar's filing or Lawyers Mutuals, but you won't attract very many people. And as I said before, the people that you do attract may be the ones that nobody else wants anyway. So you're going to adversely select against yourself, and you're going to have a small risk pool because your premium is going to be too high.
Great, thank you. Welcome,
Chair and
sir.
members, I'm Mike Below. A statewide organization of civil defense lawyers. What I think you have here at bottom is a public policy question. You're well represented, bench, bar, academia, public policy, non-lawyer expert. What you really have is a public policy question. Has a case been made that mandatory insurance is necessary, and if so, should a captive be created? It seems to me our members work in a world where it's getting harder and harder to get a civil case trial set, especially in this county, and hard to even get a motion heard. And anything that increases the percentage of unrepresented litigants will push down and make it harder to run the judicial branch. Right now, you have family law cases in California where somewhere between 75 and 90% of cases have one or both of the parties unrepresented. The legislature has been dealing with trying to get services for undocumented immigrants, hundreds of thousands, maybe millions of people going without a lawyer. Family law, I already covered that. Unlawful detainer, half of the cases in LA are unlawful detainer in civil departments. And again, large number of unrepresented people. Anything that drives up the cost of providing legal services is a bad idea. Now, is there a problem with people getting judgments against lawyers that they can't collect? Perhaps, but it's anecdotal and vastly outweighed by the access to justice problem that you have for people who can't get or afford a lawyer. So another $3,300 per year, if that's the number, will make it incrementally harder to afford and get a lawyer, which will further burden the justice system, make it harder for our members to do business in California's courts, and that is a public policy question of the highest order. So we would urge you, first, do no harm. And we believe that while, again, there may be an issue with access to justice and fairness in terms of collecting on judgments, the bigger problem that the bar ought to be dealing with is getting representation for people who need it in areas like family law, immigration, unlawful detainer, and others. So respectfully, we would oppose a mandatory insurance requirement if presented to the Board of Governors and beyond that in the legislature. Thank you.
Thank you. Good afternoon, sir. Welcome.
Thank you, Randy. My name is Al Hernandez, and I've been an insurance agent, a broker for 28 years, handling legal malpractice, specializing in legal malpractice in California. And in all that time, I have never had an instance where I was not able to get insurance for an attorney that wanted insurance. The price might have been too high for that attorney, but the insurance has been available. Currently, in this market, there is so much insurance available. There's programs, independent contractors, new indemnities, defense firms, small firms, large firms, part-time attorneys, criminal defense firms, all these, there's a lot of programs that are currently available in California. It's just, it's astronomical, the amount that is out there. The distribution of the legal malpractice insurance, I think that currently the way it is, with the varied interest in the varied areas of practice and claims activity and just the overall structure of the law firms, California is such a vast state. You have maritime law, you have IP, you have entertainment law, you have environmental. There's just so many things. To try to find a one-size-fits-all carrier for that is, I don't see it happening. The cost of legal malpractice. $3,300 is just too much. I did a search of sole practitioners, based on the information that was being provided. I've seen all the webinars. We calculated that it was about $2,400, 62 for 100-300 limit for sole practitioners. I have a firm in San Francisco that is taking advantage of the size of firm credit. They have 5 million limits. 5 million, 26 attorney firm. They are paying about $2,700 per attorney. You're going to ask them to pay $3,300 5,000, 6,000, 10,000 for 100, 300. I think that what needs to happen is you guys have, I've seen your work. Thank you very much for what you've done. And I think that you've really had a very difficult task. I don't think you were given enough time. I don't think that there's enough information. There's data lacking. I just think that really you should have been given maybe 3 years to study this because just so many things that have been unanswered. I mean, listening to some of what transpired here today, I think I'm a little more confused than I was at the onset. And it's just, how do you, it's just, insurance is his own language. And I think maybe education is key. Educate the attorneys and educate the general public. People don't know about legal malpractice. They don't know what that is. Attorneys don't know, can't explain what claims made is. And last thing is educate the carriers. There's already systems in place to have the carriers provide some low-cost insurance for pro bono, part-time. The carriers don't do that. Educate the carriers. Thank you.
Thanks, Al. We appreciate your comments as well as your written submission.
Good afternoon, everybody. Brian Roars on behalf of Lawyers Mutual Insurance Company, who has for the last 23 years as a mutual company provided dividends to their members. I'll move on.
A point not lost on us. Only because I saw Kathy cringe.
Why Kathy didn't speak up? Never mind. Okay, so
we got it.
Here's the concern that I have. And I get it not just myself, but also from people in the industry, and that is that perhaps a decision has already been made by this committee. Some evidence for that is a recent phone call where there were many people on the call. Mandatory insurance was being discussed, and a representative from ALPS said that ALPS is a consultant for this committee and is working as a consultant for this committee, which I did not know, and I'd like to know. I'd like to know if either formally or informally ALPS is acting as a consultant for this committee, and if the answer is yes, I would like to know why a carrier that does not even write malpractice insurance in the state of California would be selected to be a consultant when there are many carriers who already write in this state and have for 40 years, for instance. From what I heard today, had a lot of discussion about captive carriers and mandatory carriers, and the question I have is, when will be the day that admitted carriers in California who currently write policies in California can come before this committee and be told, hey, here's the need in California. How can your company meet that need before we turn this upside down? Because if you vote for mandatory open, 2 years from now, 3 years from now, here's the headlines. Insurance companies are deciding who can practice and who can't, and then the state bar steps in and creates the captive carrier. And I don't think anybody wants that. Thank you. He was here at that very first one in San Francisco. I don't know what the ALPS, it's attorney. They write for
Attorneys Liability Protection.
Yeah, they write for the tiny
They
states,
actually
North
did
Dakota,
write-
South
their-
Dakota.
Their file to write in California, they wrote under the Clear Blue program to the reinsurers non-renew their contract.
Pardon me. Yeah, they did. Yeah, just to be clear, ALPS is not a consultant to the working group or the state bar, nor do we have any consultants other than our own work in discussing the issues with people involved in the industry.
And can I add to that? There's been no decision made about anything by this group, and Bagley-Keene prevents us from having too much of a discussion even amongst ourselves outside of the open meeting laws. So there, you can pretty much gather what you can from the open meetings as far as how people might feel, but there's been no polling of the group at this point, and there's been no decision made. So, and if it has, I don't know where I was, because I wasn't part of that.
Thank you for that.
That's right, Joanna. Well stated, because there's a lot of people going around thinking that we've made a decision, and that's just absolutely 100% wrong. Everybody's here with an open mind, and what's been discussed in this room, as far as I know, is all that's been discussed.
All of that is true, and I was going to wait to the end of our public comments to make that point, but I'll make it now since we put it out there. I believe one of the speakers mentioned that there was a preliminary recommendation. There are no preliminary recommendations. The recent request for public comment merely summarized the sort of issues that we are dealing with, but again, all of it has its genesis in the legislation. Those are the questions we've been asked to analyze and assess and provide our findings to the State Bar Board of Trustees. That's as much as we've done so far. So we have no interim reports, we have no recommendations, we have no sense or feeling, but these are open forums and we encourage you to be part of all of it, and you can hear exactly the types of things we're considering. So for those of you that follow this on the webcast or those of you here today, we appreciate very much your involvement in this, and we'll continue to do what we need to do to be responsive to the legislative questions.
Well,
Mr.
thank
Berman.
you. My time is up. Basically, my name is Ron Berman. I'm a lawyer practicing with Berman, Schneider, and Lowry. It's my whole family and one other. So, and I've been doing this for 40 some odd years. And 10 years ago, when I was a member of another section of the State Bar, I was tasked to put together their recommendations regarding disclosure. And of course, we also talked about mandatory at the same time. And we ended up with that rule at that time as Rule 3-410, which is the 4-hour rule. And that was because of a gentleman up in Auburn who didn't want his friends and neighbors calling him and asking him a question. He says, if they do I have to tell them whether I have malpractice insurance or not? So that's how he came up with 4 hours. But at any rate, let me mention something that I really wasn't going to this in the way of subject matter, but the captive concept that was mentioned by the previous gentleman, he mentioned Washington, D.C. For example, you look for a friendly state to do so. Washington, D.C. happens to have a requirement of $400,000 as the initial capital to become a risk retention group. And they also have, if you have a risk retention group in Washington, D.C., it's covered by the Foreign Risk Retention Group Act here in California, and is supposed to report either to the Department of Insurance or to the Department of Industrial Relations. And with a risk retention group, there's no SIGA protection of $500,000 that would be available to someone who had a problem and needed to do with that.
Is SIGA like FDIC sort of for banks?
Pardon me?
SIGA, what is SIGA?
California Guarantee for insurance companies that go under.
Yeah.
So sort of like the FDIC for banks?
Yes. Correct. Going back to the subject at hand today, we looked at it at that time, and the basic problem is that there were 30,000 lawyers at that time, and there generally is, according to what I've heard, 30,000 lawyers that are bare at the present time. And criminal lawyers don't have legal malpractice insurance. I asked my friends about that at that time. They had a nice laugh and said, we don't have legal malpractice insurance, nor do we intend to buy it. There are other groups, I'm sure, that would look at it the same way, and there's probably more people at the present time that do not have the insurance. Making it mandatory on these people, whether it's an affordability issue or not, is a basic problem. At the same time, you have a diminishing limits policies. So, and if they're a small policy, which most uninsureds will buy just so they don't have to tell their clients that they don't have legal malpractice insurance, they'll buy the smallest available policy. Yes, sir. Okay. let me just finish that one point, that basically what you're looking at is the availability to pay judgments or settlements, but by the time the carrier appoint somebody, and then that doesn't count. But when you're looking at the lawyer's time, and even if the lawyer says on a 100, 300 policy, I think we should settle this case at 80,000, the carrier may disagree. So now you are in now you're in this position of burning the limits while you go to work on it. And so it's like a teeter-totter. You go one way, which is your costs and fees, the other, and while the need for a verdict or a settlement is still going to be $80,000, but you're eating away at that 80,000. So the victim basically does not stand much of an opportunity of being compensated appropriately. And so I think you need to work with the commissioners and the insurance companies in order to develop a proper plan that will allow them to have a SIGA in case the company goes bust, and at the same time, the burning limits issue is going to exist at all times. And finally, if you go into a risk retention group, there's just overwhelming questions that would come to mind. For example, are all the members jointly and severally responsible for the acts of the other members? I will do it as I back away slowly from this from the microphone.
Well, otherwise I was going to have my intern try to collect the microphone from you, but
That's
it
quite
appears
all
to
right.
get people in
You
trouble.
can take my pacemaker while he's at it.
There's nobody kneeling down there, Ron.
At the same time, when you start a risk retention group, you need an actuary, you need an accountant.
Ron, send it in writing. Send a written comment in, because we'll
And-
be able to absorb it then.
I will do so, and I thank you for your time.
Thank you, Ron.
Thank you.
Have a
We
good day.
appreciate you coming, Ron, very much.
I'll raise this for the next week.
All right. Any other public comment? Did we get to everybody? Again, thank you for all of you for participating and making the comments. They are very, very valuable to us, and we very much take them to heart. Appreciate your involvement in the process. So with that, for purposes of the webcast members and those of you that are here, our viewers, listeners, and those of you that are here, we need to move on to our working group discussion. I'm gonna turn this back over to Mark and Glenn to sort of kick this off. This is a really important part of our process here. Each of the committees, the meetings that we've had, we've dedicated to a single topic, and then we've left ourselves time. And this is not the only time that we can talk, but Bagley-Keene suggests that we need to do so in a open forum if a few of us gather together. So now's the quick and easy time to do this, and to take advantage of this time, I'm going to ask that you guys lead the discussion.
Microphone a little better. I think so. There we go. Okay. A couple of the things that resonated with me today, and I'm just going to toss these, open for discussion, and Mark can weigh in as well. But I thought it interesting. Some of Professor Spitzer's comments I thought were kind of enlightening. One of which is they did a little bit more of an effort to understand the scope of the uninsured lawyer problem than perhaps we have, and then perhaps other states have. And what they did it in the context of the registration. People sign up, they say, I've done my CLE, I have a compliant, trust fund, all of that. So they had their hands around that a little bit more, and that was something that I took from his discussion that I thought was interesting. And then kind of an adjunct to that, which I thought was interesting from his talk, was that they had some testimony from people coming in saying, hi, I'm a client who had an uninsured judgment. This is kind of what happened to me. And I don't know that we can get the benefit of that, but I thought that was was really an interesting, thing. And I think maybe they ended up where they did, and we were marveling at the fact that they actually had some consensus, in their group, um, because they had that information, or at least they had, that in front of them. I think from Carol Bernick's talk, I took that these captive programs, if you can get them up and running, have some really kind of robust benefits. I mean, there's some very interesting things about them, not the least of which is you are the owner of all of the claims data. I mean, you can actually put very experienced people on the ground to kind of study everything. Um, I think we've heard, though, in the context of some of our, other meetings that, that exists in the universe anyway. It probably exists with commercial insurers like Scott's and, Company and LMIC, what Kathy works for. So a lot of that benefit is kind of existing in the universe anyway. The premium amount kind of bounces around, and I'm interested in other people's thoughts about this too, that in any given meeting, you can hear that $3,300 is exorbitantly expensive or very cheap. And it's very difficult to kind of get your head around what does that mean? Is that something that's just completely out of step with what some lawyers in California can pay? Or is that something that, is actually a reasonable and premium or assessment or whatever that we could expect to be, that lawyers to be able to bear? Yeah, Scott.
Yeah, no, the one thing that I thought was remarkable about that with Oregon is that it's $3,300 per attorney. And so there are a lot more large firms here than in Oregon, and I think that would have yet you're only getting $300,000 in coverage, and you could conceivably have your firm paying $330,000 for $300,000 in coverage. And that seems to be like, that would be tough for people to swallow.
It would be interesting to get Latham and Watkins on the phone on that one. It's like if you did the math on that, yeah, you're right. I mean, that's an interesting issue. You've got one limit that's covering essentially everybody, but you've got this assessment that kind of attaches to each lawyer.
So
what does that mean?
if I can just comment, and I don't think this breaks with Bagley Keene, but during the lunch, I did have one conversation with Carol, and she did say that firms that have their principal place of business outside of the state of Oregon are not subject to that requirement to take part. So Latham and Watkins, for instance, presumably doesn't have their principal office
right
in Oregon, so maybe they wouldn't.
Yeah.
I was going to say.
Right. No,
there's
but
a lot more
but
than
I
in
was just
California.
saying, that they may not, and it may be that there are not any 100 or 1,000 attorney firms in Oregon that they can apply.
Yeah, that is something that that's a difference that we didn't really plumb today, which is if you look at Oregon, you've got Davis Wright, you've got Bullivant Hauser, there's a couple of, very large firms, but there isn't the plethora of very large firms that we have, the Morrison and Forsters, the Gibson Dunn, and how operationally would an assessment like that work in California? It's an interesting dynamic, and you'd have to look at the actuarial piece of that, I think, to really get your head around it.
There was that, and then also that in the Canadian model, they said that they did a startup where they charged every attorney $10,000, which I thought was also, I mean, that would create a great fund for the California if you were able to accomplish that, but I think it would also be very painful for a lot of people.
Right.
And I don't know that how many people would be in favor of doing that.
Yeah, I think the other thing that kind of jumped out at me too I think Kathy, you might have had this question, but it's possible for captives to fail. It's possible for programs to not be successful. So it's not a foregone conclusion either that you can put one of these things in place and actually have it succeed. There was the Andler experience in Virginia, and that's one that didn't make it. And I think Dan Pennington kind of highlighted that too. Even Law Pro in the early days it was under-reserved and had to be essentially reconfigured to become a successful program. So it's not a foregone conclusion that they always succeed.
Yeah. In part, why I was asking what the structure of the formula would be just to get this gigantic plane off the ground and not have it crash. So, just things like building the infrastructure of the plane and underway.
Okay. So my takeaway from today, and as we were preparing this, we tried to get a fair picture as to what captive actually meant. And I concluded that it was really the secondary question. I think what everything we heard today makes me think that this working group, we've heard a lot about the issue of whether or not we should recommend or whatever we're going to do. The threshold question is, should there be mandatory coverage or mandatory insurance? Because the information we've been gathering about open market versus captive is just way too much for us to get our arms around. The folks in Ontario, in American dollars, they're paying for $750,000 per claim. They're paying $2,250 a premium. In Oregon, they're paying $3,300 for $300,000. That's such a disparate picture that this group is really not going to be able to plumb deep enough to that on that issue. And one of the things I asked Carol at the break was how much money they spent on what she deemed loss prevention. And they spend $2.4 million out of 9.6. So that is far and above a mandatory policy. They're providing a far greater service than that. And that adds up to, I did the math, for 7,200 lawyers, they're spending $333 per lawyer for loss prevention services. And that's, again, that's an add-on, and it's not just insurance. So it sounds like there's a number of reasonable choices, or there's a number of options that need to be studied, but the threshold question that we have to answer is, are we going to be a state that requires insurance? And as Professor Spitzer said, they looked at it as protecting the public rather than protecting the lawyers. And I think that that's a great way to look at it. And that's what I walked away from this day of presentation and everything Glenn and I have been working on.
Thank you, Mark. I got to do something now. I apologize to interrupt, but I'm going to lose my guy corner. I'm going to lose Scott here in a little bit, and I know you wanted to comment here before you go. I'm going to lose Greg. Linda and I have talked about the choreography from here on out, so I want to make sure I had everybody invested in it before we start losing folks. And obviously, the process is the last meeting where we mentioned that the legislative questions analyzed and presented to the subcommittee. So we're now completed with that process. So now we start to have to look at what we do from here. So we scheduled another meeting, first of all, on January 14th. I hope everybody can make it. Oh, what? Oh, okay. I was thinking we did this new. Never mind. So show up on January 14th. It's been on your calendar for a year. Up in San Francisco. And that'll be an important meeting. What we talked about in terms of what we do between now and then is there'll be a lot of work to do. What we need for subcommittees to do is to meet, discuss your topic, and come up with your assessments, conclusions, evaluations, recommendations. What we'll do is discuss all of that at the January 14th meeting. Did you and I agree on any sort of written submissions from each of the subcommittees you'd like in advance?
The big subcommittees or the little subcommittees?
I think it has to be the baby subcommittees for the baby game.
There's not a requirement for recommendations. There's not a legislative mandate for recommendations. You have to report, the board of trustees has to report on its findings. So this working group may or may not include recommendations. the agenda for January 14th was to look at each subcommittee presenting their findings and recommendations, if any, to the working group for then to discuss, and the working group would come to a final decision about what to include in its report and what recommendations.
But do you mean the small subcommittees or the larger subcommittee?
The larger subcommittees, so there are 4 subcommittees.
Okay.
So, yeah, that's
Okay.
the structure. You all know who you are and who you're with.
Can I ask a question on that? Because you have one subcommittee that was just described is addressing the threshold question, and that's leaving a majority of the committee out of that. That concerns me because I don't know if those subcommittee members feel one way and the rest of the committee feels the other way. How do we address that?
So I think the idea is for the subcommittee to present what its position or its recommendation to the group, but it's really the group as a whole that will make the decision. But when we talked about it before about the working group as a whole making recommendations, what people have said is each of the subcommittees really has the inside information. So I think the idea is for each subcommittee to make its case or present its information for discussion if they haven't come to a particular position, and then have the working group as a whole look at each topic to decide whether it should be included in the report and any recommendations. But it would be the working group as a whole that produces the final product.
Just
Yeah, that obviously is what we'll use to guide us in the meeting on January 14th, but also the recommendations for your findings or your assessment that we're going to write for that. So you'll need to organize your subcommittees into some format where you can produce that. And we'll have that.
But will the subcommittee reports talk in the context of the thing as a whole? Like if you're on disclosure, you could talk about, and our thoughts on disclosure play into mandatory this way, or our thoughts on availability and affordability play into the overall charter, right? I mean, so we don't have to limit our subcommittee reports, I assume, to a narrow slice, because it's all towards the questions in the that we got, right?
Yeah, I think you should look
I
at.
think, because I mean, I would not want to be, a gag order. You can't talk anything. You can't mention any feelings about mandatory because you're not on the mandatory committee.
I was just going to.
I agree. I agree. You're not going to be in any particular silo. And matter of fact, some of these rules would, or the proposals, topics are obviously compatible with each other. So you might look at one thing to say, okay, well, if it's going to be mandatory insurance, then that's the way, we're going to, orchestrate our findings. If it's going to be disclosure, that's maybe a better way to go. So all these are in context of all these proposals. We might say we're going to do all of them. We might say we're going to do none of them, but don't look at it in a vacuum. Does that make sense?
It does. The only thing that I would say is, though, that if it was a disclosure if somebody's working on a disclosure requirement and then we went with mandatory insurance, then you wouldn't need disclosure requirements.
True.
So I guess that I think is what the comment was over here kind of getting at, is the idea that, like, you said some of them work in coordination, but some of them kind of, if you have one, then you wouldn't have the other.
Probably. I mean, there would not be a need for, well, disclosure, I guess, would still be an issue in terms of how, it depends on what form of insurance, but it would be still something that we would have in place, depending on where we come out with the mandatory insurance piece. So.
But Scott, I'm not on the disclosure one, but the disclosure one could still say, to the extent there's a problem, here what we think the disclosure rules would address, and therefore that mitigates the need for mandatory. I mean, so it still bleeds into.
The other thing to keep in mind is that this is not any proposed rules. No matter what happens, this isn't going to result in the Board of Trustees proposing a rule. This is a report to the legislature and the Supreme Court. So even if the Board of Trustees recommends mandatory insurance, the legislature might not decide to implement that. And so the report could say, in the case that mandatory insurance is not imposed, this is something that can be done to further protect the public. So I don't think it's necessarily one or the other. I think we have to look at it in the context of what the intent of the report is.
Kath?
Just to make this real simple, and we are permitted to reference other subcommittees, obviously information, what they've presented, and how it can impact us or our subcommittee, and then have kind of a summary of all of it in each of those individual reports. Is that right?
No, not
No.
really. Yeah, you
Okay.
mean in terms of the subcommittee
Right.
taking a position or making some recommendations on all the topics?
Well, if, for example, disclosure, if you say that mandatory is necessary, then you don't need disclosure. If you say mandatory is not necessary, then you might say disclosure needs to be beefed up and here's how. So in essence, it's a one hand and other hand conversations, but talking about other topics. Is that
Yeah.
permitted?
Well, you can certainly talk about other topics, but I think for disclosure, for example, you would say, assuming there's not
Yeah.
a need for some form of mandatory insurance, here's what we'd recommend doing with the current disclosure rule.
Right.
So that sort of cleans it up that way. Jay?
There we go. It doesn't necessarily flow just in that direction, because I assume the disclosure folks, if they said we can achieve all the public interest we're trying to achieve through effective disclosure, that would inform the decision of whether we have mandatory insurance. So that's the ultimate question, but I don't think it's the first question. So I would just urge everyone to think about the particular question they're working on, but they're all interrelated, and I don't think we should try to shy away from that.
Right. Heather?
I was just going to say, my view of this when I heard about this process was this is really a chance for small, nimble groups to put their thoughts in writing, with your topic being the first thing that you mentioned, but free game to comment on anything that interrelates. And then instead of having 20-some ideas, we have, how many groups are there? 5? 4. We have 4 pieces of paper, and we're closer to reaching a consensus because we're really only working off of 4 documents. That's how I view it. And there's no possible way that our group is going to be able to contain ourselves to the strict parameters of our topic just because there's so many interrelated parts of it. So anyway, that's my view of it, and I would, if that's consistent with our approach, I commend that approach.
I'll work to schedule meetings of the subcommittees, telephone meetings in between now and January, and the January meeting, so that we can have the written reports from each subcommittee posted to the agenda in advance of the meeting.
How many days before does that have to be done?
The agenda has to be posted 10 days in advance of the meeting.
Linda, do you mind just in a minute discussing like the procedures for drafts? Like if, for instance, if I did a paragraph and I wanted to send it to my committee members, I think I can't do that. Would we just wait for the telephone meeting and read it out loud, or how do we?
We can
just in order to comply with our Bagley-Keene requirements.
Drafts can be posted to the agenda for the individual subcommittee meetings, but I think we can't share offline, pass things back and forth. I think that all has to be done publicly.
Okay, so we either post it. We can either post it to the agenda, or we can read it, literally, we can just read it during the meeting that's been adequately noticed.
But one of the ways we've dealt with this at Mark Time is we've had committee members send their comments to the staff person. The staff person incorporates to the extent possible, I mean, it becomes challenging when they're conflicting, and then the staff person can send out another version. So we've done it that way as well.
The only caveat to that is you can't do multiple rounds.
That's what I mean.
Of that.
We don't necessarily want to publish, like, a very, very, very rough draft. Is what, but maybe reading it out loud isn't such a bad deal. Sorry, I'm a little overwhelmed about that.
I think if we have a couple of meetings, then there can be the rough draft conversation at the first one, and then it can be compiled and polished.
So I'm just
just for clarity's sake, what we would be doing in the first call, for instance, would be saying, you know, this is a call to generate a draft around our recommendations. This is our topic. This is the tentative direction we're going, and then that's what gets posted. Then a second step is we finalize it, probably, right? Okay.
And it doesn't mean, correct me if I'm wrong, it doesn't mean there can't be individual conversations from the subcommittee chair to say, you know, individually to, you know, create this part of it or draft whatever you want to draft or collect your thoughts or look at your notes or whatever. All those things I think are probably obvious and helpful in that process. So that way, you know, when you have your time together in an open subcommittee meeting, you'll use it productively. So there's probably some advanced work that you need to do to make sure that, and you guys went so recently, a lot of it's probably in mind, but for the folks that, you know, prepared their assessment 3, 4, 5, 6 months ago, you're probably going to have to go back and revisit that. But the good thing about those that went earlier is that now you're informed by a lot of the other discussions, and maybe that's helped you sort of assess your individual topics a little bit better, or at least in context as well.
And further to that, especially keep in mind that this is about a quorum of any of the subcommittees. The limitation is on having a quorum of any of the subcommittees. So if you, I think they're all 4 or 5 members. So any 2 of you, it just turned on. Linda, you just took it away. Okay. So any 2 people can collaborate and communicate with each other. But if that gets reported out, then the reporting out of that collaboration has to be in the context of some publicly noticed meeting.
Makes sense.
Yeah, Greg, go ahead.
I apologize. I'm going to have to go catch a plane, but I just wanted to, I know we're now getting into this phase of the group where you're putting pen to paper, thinking about recommendations. The report goes to the legislature and the court. Closer, and the court has no preconceived notion as to where this group would come out or where, I don't, individual justices may have ideas about mandatory malpractice insurance. If I were a betting man, I would bet very few of them do because they haven't given that much thought to it because they haven't been asked to at this point. But when they do get a proposal in front of them, they're going to want to know what the case is for changing this. And when we get to mandatory malpractice insurance as a requirement to continue to have your license renewed on an annual basis, we're moving into the inherent authority of the court over the regulation of the profession. And so they're going to want to have a good sense of what problem are we trying to solve here. So as you think about the recommendations, I just want to try to relieve some pressure from any of you that may be feeling like you need to come up with a final decision on some of these things. I think a recommendation can also include areas of further study, areas in which we need more information. And I go back to Professor Spitzer as well. And by the way, wonderful presentation today, very informative. But they seem to have very good information in Washington State about the number of uninsured attorneys. It sounds like they gathered some testimony from disgruntled former clients of attorneys that were unable to bring a claim because the attorney was uninsured. If that is something that we need to do, then perhaps we need to develop more of an evidentiary record, and that could be a recommendation as well. This doesn't have to be a be-all and end-all report, is what I'm trying to say. It can be a step in the process. Because as a lot of public commenters indicated today, it's a serious step to require this as a condition to maintain your license, especially in a state like California.
First of all, can I say I think it's so funny that these show red when they're on because red is an off color. So just saying, I think that's
Maybe
confusing.
that is why we were like discombobulated.
may account for a lot today. But I just wanted to tell you I found that very impactful, Greg, what you said about, here's other things we may need to do, other data that we need to collect. And I don't know the answer to this, and if Linda happens to know it or Mark happens to know it, maybe you could let us know. If not, maybe this is something we want to include in our recommendations, because I too feel that we're lacking data. I've said this before. I said it in the first meeting. I've aired it in these open meetings. Other states, obviously including Washington and including Illinois, where I'm licensed, on your fee statement for your mandatory fee, it asks you, are you a small solo firm practitioner? Do you carry malpractice insurance? What is your limit? Do you have a client trust account? All these questions that allow you to gather information which would be pertinent to our study. And we don't ask those at the State Bar. We haven't in the past. So, oh, and Leah's here now. Maybe she would know the answer to this. She'd be the best person. But maybe those are being asked this time, Leah, and I apologize for springing this on you here. Or if not, perhaps as part of our recommendations, we may want to suggest specific ways that the State Bar can collect additional data to allow us to make more meaningful recommendations during another stage in this process. I just say that because I've heard us for a whole year now talk about how we wish we had more data about California attorneys. And I need to commend Linda because she's gone out of her way to get data about California attorneys, how many carry malpractice, what is the breakdown, but the data just isn't there in California. We don't have that data yet. We didn't collect that data. Anyway.
Well, we didn't. We didn't collect it, or California never collected it in global sense. There was a
No, I know.
survey that was
Right.
done in the past, and there's certain extrapolations we can make from other bits and pieces. I mean, I agree, we don't have the data that gets collected at the licensing stage, annual fee stage.
And Washington has a rule, Randy. They have a rule that requires it.
Many states do.
Yeah.
And so that's obviously really reliable data that would get you, the information you're looking at. That said, we know that it exists. We know that there is a major fraction of the small firm lawyers and solos in the state that don't carry insurance. That maybe 10%. I think the number is probably 25 to 30%. But you're right, we don't have the empirical data that's been collected in an official capacity to back that up. And so it's there. But I do agree it would be better if California had a policy of collecting that, either as an interim step or a step that we would recommend before we can act without the empirical data, or just something that's good to do. There's lots of arguments about what questions can go on censuses these days, so I don't know how the bar members and licensees would react to something like that. I think the bar can ask whatever it wants to ask.
This raises for me another question. And so in general, I'm hoping that it will be acceptable for our subcommittees to maybe submit thoughts or recommendations, in our subcommittee reports on issues that weren't originally anticipated in the legislation or even in our committee, missions. Because to Heather's point, in the area of collecting data about attorney experience, totally agree. It seems to make sense that we ought to consider making recommendations for those kinds of things. And the one that has occurred to me throughout our work on our subcommittee and in lots of conversations with folks is how difficult it's been to bring public interest groups, the non-lawyer community, the non-insurance community, the more traditional public interest community into our deliberations, to reach them in an effective way that would bring them into our public comment periods, to reach them in a way that would have maybe engendered some response to this initial public comment request. And so I will share with you that one of the recommendations that I will be looking to hopefully include in our subcommittee report is a general recommendation that the bar ought to consider devoting staff to really developing that database and those relationships, so that as decisions are made going forward, that we would recommend that the bar do some specific things to improve sounds too critical, but to improve our relationship with the public interest community, to bring them into this process, which I think we've all made a huge effort to accomplish. Linda's been great working with me and others to try to get that to happen, but it hasn't happened. And so I come to this point of the discussion realizing that one of the things that I would hope that the bar would do is recognize that one of the things we learned through this process was that we don't have an adequate database and relationships with the traditional public interest community, and that it's probably in the bar's interest going forward to prioritize that as a staff function.
Thank you. Anything else on the process, procedure, the shape of these initial subcommittee reports? Okay.
Well, just Randy, just to Heather's point, which I think is a very good one. If we're looking at data and we're looking for more data and we want to have a step forward, I think at the same time we can say we know enough about what we studied to know that there are hurdles, significant hurdles associated, for instance, with a captive, insurer or with a mandatory insurance requirement, and here's what they are. And before we would perhaps take that leap, we would want to know for sure that we've got the data set to support it. So I can see those two things operating in tandem, not to, prejudge what we ought to be doing or the direction in which we would go, but that's just how it lands on me.
Yeah, I can understand both those comments. I think, and what Greg said, I think are illuminating for us when we come to the subcommittee assessment or conclusions, recommendations that we may say, here's where we're at right now. Yeah, here's our thoughts or recommendations, but here's what.
You sound like Hal from 2001.
Yeah.
Thank you, Dave.
At our next meeting, we're just going to get paper cups with little string between them. I think I will bring those. Or the little toy megaphones that distort our voice. In any event, so I think it's great to put that out there because it gives us perhaps a flavor or a different way of looking at these issues. If we're not in a position where we have the data that's fully developed, maybe we want to put that out there and suggest there may be ways to gather it. Other than that, I'm done in March. Kidding. Okay, anything more on that? Okay, good. So thank you for that time. I needed to do that before we lost Scott and Greg. I think that was a useful discussion to have. So on our time remaining, Glenn, and Glenn and Mark, if we can go back to where we left off on the captive subject. Mark, I thought you had some great comments on that.
Yeah, I think maybe just the last couple of bullet points that I've got about the kind of getting our heads around the idea of a captive insurer and what that would mean. The Oregon program, and this is both from talking kind of in sidebar with Carol, but also in the presentation, really is kind of a unique animal in a lot of different ways. The way that it was set up in the hard market and the fact that they had a smaller population of attorneys and had the insurance department waiver, and there were a lot of things that kind of came together to make that happen. Kind of playing that against what Courtney, talked about, which is what do most people do in the captive universe when they set one of these insurers up? It's kind of a fronting organization with reinsurance behind it, and you're paying somebody somewhere to do your claims handling, to do your actuarial data analysis. I think if we were to end up in that world isn't, at least to me, significantly better than a competitive market with really good insurers going at each other and trying to provide a product. So, if we were to, and at least this is the way kind of meshing all of the presentations together, it lands on me. If we were to seriously consider a captive, the best captive is something like what Oregon does, but just think about the scale of that in California. And I think we even heard it from Dan Pennington that the perception is that Oregon is kind of an expensive administrative structure, although it's a very good one, staffed with fabulous people. How do you get to that point? That's probably the most effective entity, but it's a fairly unwieldy thing for us to do. And I don't see the case for the commercial piece as strongly. And I'm just interested in other folks' take on that. But that's how I read those two presentations together.
Sure. Anything further on that? Ruben?
Randy, I do. So the one thing that keeps occurring to me is that when we're having the discussion about captive or Oregon's model and the numbers that they're using, so the 3,300, I feel like it's a trap to think in those terms of those set numbers, because our population is so different and so big that and I'm not a statistician, and you're right, if I had been good at math, I would have gone to medical school. But I feel like just the scope of our insureds or our coverage is going to change those numbers significantly. And I feel very handicapped in even starting a conversation about whether it's too expensive or not without having some statistical analysis about actuarial, how much it's going to cost for our big group of lawyers.
Yeah, and I think there were some really interesting points made, kind of a dialogue that you had, Randy, about that look, to really understand that universe, you would have to look at all of the commercial insurers. They're not all admitted carriers. I mean, some of them are surplus lines carriers. I mean, you don't necessarily have their filed data. And then you've got to look at this uninsured gap, this delta of who are those people, what would their loss experience be like. And I thought from Courtney's presentation, it's fairly important to kind of understand that entire universe as best you can. And you wouldn't want to go there without due diligence, like reading it all together.
I don't think that, I mean, certainly the scalability of this, the sheer magnitude of a captive program here in California, now that we sort of understand the components of it, you'd obviously need to collect enough money to be able to pay claims expenses and pay indemnity under policies and have a underwriting staff, et cetera, and the starting line of that really concerns me, because I don't know whether we're taking on prior acts. I don't know whether everybody starts with a clean slate, and then you're importing 30,000 or so uninsured lawyers that we don't know. Maybe they're not more risky, but I think there probably is some correlation between not having insurance and maybe having a riskier practice. I don't know that that's fair, but that may be a safe conclusion to draw. So sort of worried about the starting point of that, but if we were to get over that hurdle, there are smart people available that could do the due diligence to assess all this. I'm just afraid that once they got through with all that process, and I don't think we're talking about building in a rate of return or 10% or 15%, so the bar or the organization can make money and do other things with it. We're just looking to make sure that everybody's under the same tent here. That's the goal. That once they look at all that, I just don't know what that looks like, and I'm afraid what it looks like is a big number to under that rubric, under that organization, to each of the lawyers, and the coverage, at least what I hear from Oregon, the fact that each individual has a $300,000 limit and it doesn't stack. It's just not that valuable, but it does bring those uninsured lawyers under the tent. So.
Yeah, I mean, I think that's the challenge, to try to read it all together and kind of understand what it means. And when we described this to Courtney, I thought was fairly interesting. We gave him the simplest model of all, which is assume that what you're doing is you're coming in and you're providing a $250,000 per claim and aggregate policy, or $300,000. And you're not picking up prior acts. And all you're doing is providing that primary insurance. In his universe, that's a pretty simple model. And claims made. So you're actually not having a lot of complexity putting something that has that limited a primary insurance exposure together. The devil is in the details. The devil becomes, what do you do with prior acts, existing claims? How do you start? What's the cutoff from the prior, market? How do you transition effectively? You really have to be able to provide the excess insurance, I believe, because if you don't have that facility, it's going to take a while for the private market to reorganize, right? And to start to write over your program and offer excess insurance. It will happen, like the speakers told us, but it won't happen instantaneously. So it's very interesting that when you look at the Ontario program and you look at the Oregon program, they always have a facility to be able to provide the excess insurance themselves. And I think that's part of the reason, because they want to control and at least, smooth out the irregularities of the private market if somehow it gets dislodged.
Well, I guess in a captive program, the existing primary insurers would then have to shift to excess insurance, probably sell a lot of excess insurance. $300,000 is not a lot for, some riskier practices or big practices. So there'd clearly be a pretty significant part of the marketplace that would just shift $250,000, $300,000 upward, as a first layer.
Yeah, and I think most people who write over the Oregon program discover that it is not a very risky thing. If you're writing over solos and another carrier is picking up a $300,000 primary layer and you're writing another $300,000 or $500,000 above that, that typically is not a very high frequency event. I mean, you're not going to get hit that often.
Have you seen the Oregon laws?
Kathy says, I beg to differ.
Oregon is a kind of a unique population in as much as they have very few lawyers compared to our lawyers. And if you look at the areas of practice across our state, from Silicon Valley down to San Diego, you have areas of practice that can be high risk, extremely high risk, and cost a lot of money. And then you have some that really never cost you any money. So when you pool all of that together, which Oregon doesn't really, California is like the third world's largest nation in itself. I mean, we have an economy that's booming, and you have a diverse population. So you have mergers and acquisitions for billions and billions of dollars, and then you have an unlawful detainer down the street. So to compare us is not, it's really not the point, because I think one of the people speaking, I think it was Cindy Aragon, said for $1 million coverage with Lawyers Mutual in a metropolitan area where you have lots of litigation, because that's another factor, it is $10,000. So depending on where you are located, your area of practice, there's just no way you can assess the risk at one price and not even be profitable, just stay alive, stay afloat as a company that insures all the risks. And I think that's the problem.
Yeah, no, I think that's probably right. And maybe an excess carrier's experience here writing over a primary of 300 could be a very, very lumpy experience, right?
It's lumpy, some carriers, and I think Cindy pointed out well, and that's our experience. They come, they go, they stay 3 to 5 years, they go. Alps was here, they left, they lost their reinsurance. You have a lot of carriers that think they can come and make the profit because, as our captive guy says, it looks easy on paper. Just do the math, collect the money, and you're good to go. That's not the experience here in California in terms of losses.
Can I? Oh, sorry.
Yeah.
One of the issues that it's so detailed that we really are not capable of being able to consider everything in this working group, and we can't compare ourselves to Oregon. She said there was 165 or 168 claims in the per annum that hits the $300,000, and anybody who practices in legal malpractice, whether you do defense work or plaintiff's work, knows that in California, you're not going to have only 160 some, even if you scale the percentages of, well, we have 200 and they have 3,500 or whatever it is, and you multiply 165 times 6, we're not in the same universe. And so we can't, it's not valuable factual detail to try to analyze it.
Professionals. Oh, she said that they had 12 professionals handling about 75, 80 claims a person. That's like 900 to 1,000 claims for the entire state.
Yeah.
That's a very small percentage of what we might have here.
I think we had that in LA
Yeah.
So,
I was being,
that was dovetailing with what Mark said, I agree with you. There are such big differences. Remember, Washington State has no punitive damages. There are lots of differences substantively. Right, but they drive claims. They're not insurable, but they affect the litigation.
Yeah.
milieu. And there are lots of distinctions like that. And so we do have to think carefully about whether you can make the mandatory decision sort of in a vacuum without already having a pretty good idea that there could be a workable either open market solution for mandatory people or a captive thing. I mean, I agree with you what you said. It does seem like a foundational idea that you have to decide mandatory first, and then we'll do another few years of work to figure out, not we, somebody would work really hard to figure out how to implement it. But if you did that, I think you'd have to have an exit strategy or something, because if it turned out there wasn't any way to make it workable, then you'd have mandated something that there isn't a really good mechanism in California for, because there are just so many differences between us and Oregon for all the reasons we've been talking about. This whole unitary pricing thing, I mean, insurance, going back to its most basic origins, is about spreading risk when you don't know where the risk is coming from. So if you were in London and the ships were going out, a few hundred years ago, you didn't know which ship was going to be hit by a squall or was going to be struck by lightning or something. And so you could literally spread the risk and have 100 ships and one would go down and you all share. But the more information we have, it's like health insurance, the more information we have about practice areas, the more we have buckets. And we say, IP practice for a time was really expensive to get insurance for because it was seen as a very high exposure proposition. And then something like criminal law or unlawful detainer, you have both low frequency and low severity. And so the underwriters can figure out pricing for different little slices of the market. And same with like that comment about Los Angeles being such a high risk area to write in. But Oregon has unitary pricing for everyone because they're going back to the very original basic idea of insurance. It's like you all pay in and you all subsidize each other and suck it up. You just deal with it. And it's kind of like Obamacare and the individual mandate. Some people philosophically don't like that, and other people who understand how insurance works say, well, duh, if you're going to require people to pay in a situation where there's adverse selection and only people who are sick are going to buy insurance, well, you have to have everybody pay into that to spread the risk. So there's just so many moving parts to this that I think we'd have to, anybody who decides that mandatory makes sense would have to have at least some basic idea that there is a workable model. But I agree with you, we couldn't, the devil's in the details. So it's foundational, but it's not foundational, is my point.
I just want to better understand when you say mandatory, we'd have to make sure it's workable. What would make it unworkable? But then wouldn't the state bar or some other entity be the carrier of last resort? Is that how you'd make that model workable?
That's the problem, is if you had the state bar do it, then are you going to have a true government program? So for example, FEMA or the California Earthquake Authority, there are risks that you can't responsibly price unless you have the government backing it up, because the basic competitive market, capitalism, it's not going to work if you say you have to write. Like in California, if you wanted to write homeowners insurance, you had to offer earthquake insurance, and the carriers figured out that it's a losing proposition. They can't write that because they can collect those premiums that the hypo was posed to you. You have your home and you paid and you basically banked $60,000 and that money is just profit sitting in State Farm's account. Well, no, they paid it to somebody else whose house burned down because that person only paid $60,000 and they got $600,000 back to rebuild their house. So the problem is that if you can't have a true spreading of the risk scenario, you can't do that in the open market. And if you have an insurer of last resort, you have to be prepared to say the state of California will underwrite that and we'll put that, it'll be a line item on our budget and we'll pay these claims and we'll get whatever we can get by way of premiums, but it's not going to be responsibly priced. it's not going to be self-sustaining because by definition, the commercial market didn't do it. And so the government just eats it. And the same like with FEMA, where only people in flood zones buy flood insurance. So you can't spread the risk. If one person floods, they all flood in that area. So the government has to step in and say, we're going to just pick up the slack. And I'm fine with that if it's with eyes wide open and you say the state bar or the government or something is going to do that, but you can't say it's going to be self-sustaining if you don't set it up to where you don't have this adverse selection process where it's not bringing in enough money to pay the claims.
Well, I do have a question about that though, because I wonder if we were to mandate, let's talk about the open market model. I don't see intrinsically why that mandate, although I'd like to see actuarial statistics on it, I don't see why intrinsically that mandate would destabilize the existing market. The question becomes, what happens with the people who are not insured now? Where do they go? If they get rejected, then I think you've got to study the actuarial soundness of actually having those people insured in some sort of other facility, which could be a government facility, could be a fair plan type pool, all admitted carriers have to contribute or something to pick those people up. That I would be interested in, and that is going to be almost adverse selection by definition, that group, but it shouldn't destabilize, I would think, the existing open free market.
Right, if it's just a free market, if it's just mandatory.
They've chosen their insureds.
Right.
Whereas the captive model is very different. You are now taking, to some extent, the risk of correctly pricing that. And I think Courtney is right. You don't do that without due diligence and without a full actuarial study of knowing what you're getting into. You'd be charged by the legislature of
Well, and the
doing
actuarial
that.
study too of the point that was made about the pro se litigants, do you have a number of people? Is there going to be, and I don't know the answer to this, is there going to be a class of people, 100 people, 1,000 people, 10,000 people who were representing people who will just say, I'm not going to pay $2,000, $6,000, $10,000. I'm just going to go work at Macy's or something because I can't, what's the point of representing these people and the unlawful detainer or the immigrant things? And so we're protecting the public, and the public is civil clients or any clients who have malpractice and who are sued, but they're also the unrepresented people, the pro se litigants who don't have any lawyer, period. Would you rather have an uninsured lawyer or no lawyer? And so if that's the choice, and I don't know if it is, but we just don't have the data, are there people who would stop practicing?
And actually, if I can address that, I think it's actually a larger question even than that. Because it's not just, will people stop practicing law and go to Macy's? It's, will they stop practicing that area of law? And I think that's a huge, huge question. And it's not only the people who are doing pro bono work, but what about all of those criminal attorneys? We don't know if we don't know enough. And it seems like every single time we have this meeting at the end, right about now, we all start saying the same thing. And 5 people have said it just now. I wish we knew. I wish we had. If we had the data of, I wish we had more time. If we could only get the data for, and we just don't have it. We don't have any of this data. And imagine that half of these people who are not insured are doing criminal law. So imagine this. If this is, this was sort of said a little bit anecdotally here today, is that a lot of the people who are uninsured are in solo practice and they're criminal attorneys. So if they're doing sort of low bono criminal work, then they stop doing that. And they decide, okay, I can't afford this because I have to do this mandatory malpractice insurance, so I'm going to do something that's more expensive, or I'm going to charge more, either way. So all of their clients now go to the public defender's office. Or they don't because they don't qualify for the public defender. And so that now they're pro se. What does that do to our court system? And what does it do to their access to justice? And I think, and it was one of the members of the public, it's in my notes, I could probably look it up and tell you who, but they said, access to justice, the question of whether access to justice is the public's right to have money for an attorney making a mistake, which was also sort of testified to today, is that most of these malpractice claims are really about mistakes that somebody made. You know, they missed a deadline or they did something. While that is valid, and I'm not trying to diminish that's important, is it more important than someone's access to justice? And how many more people are affected by access to justice than by malpractice claims? And is this work group being configured because maybe the people who, I'm not even sure they are making noise, but theoretically, if people who have malpractice claims who aren't getting satisfaction for those, maybe those people make more noise than the people who aren't getting access to justice because they don't have an attorney. And that would just be really sad if that's what it is, and that there's people who are more powerful, and that's what happens. And so I just think we need to sort of keep this balance. And I'm not really saying which is which, and I'm not saying one is mutually exclusive from the other. We do need to keep it in mind. And the problem is, again, we don't know. We don't know who's uninsured. We don't know what they do. We don't know why they're uninsured. We don't know if it's really because they can't afford it. We don't know what type of law they're practicing. We don't know who their clients are. If we knew any of these things, then we could have a more meaningful and intelligent conversation about this, and then we could answer these questions.
We do know that there's a good lawyer's mutual policy out there for those criminal attorneys that's pretty cheap.
Right, because to be on most criminal panels, you have to have insurance. And so it is to get appointments from the court. So the kind of folks you're talking about are typically not representing the most low-income criminal defendants. And I do think it would be really important that we do collect the data, because there's been a lot put out there about if you mandate this, then you're going to hurt low-income clients. And we really have no basis for believing that the attorneys that don't have insurance are attorneys who charge lower hourly rates, are attorneys who are more likely to be doing pro bono work. We have no basis for that assertion. So I think, Heather, I've heard you make that comment a number of times. We are going to add questions to what we ask attorneys when they pay their licensing fee, and then when they choose to go inactive, a different set of questions. And I think we can certainly add that, but there's got to be some additional questions that try to get at this issue. If you don't carry insurance, it's almost a sensitive question, like what is your income and what's the hourly rate you charge and what practice area are you in, to really get at this issue. Are they related?
Right, and I was basing it, well,
It's the solos, but not their income and what they're charging.
right, and I was basing it just on what one of the gentlemen said in the public comment today. He mentioned that a lot of people he knew from the past, I believe he was on this same committee or a similar one 10 years ago, were criminal. And so, again, we don't know, all of it is just sort of anecdotal, what we do know or what we don't know. And then when we had the pro bono, low bono attorneys come in, they, again, just sort of from who they knew, mentioned that they thought it would make it harder. And in the public comment that we had that was passed around earlier, that was listed in the public comment from the people against mandating, that they said they thought it would affect access to justice. And so I just think we need to explore it, because if that's the case, and that's just a big if that's the case, I think that's a big problem.
The criminal bar, I've been to many of their events. The criminal bar has a Wiley case that protects them in effect from legal malpractice, because it basically says you have to be innocent to have legal malpractice. And so a lot of them believe, well, I'm never going to be proven to have committed malpractice, therefore I don't need insurance because nobody can really succeed against me. So you have that, which is different than any other area of practice. No other area of practice has a case like that. Second one is we developed the criminal program for the very reason, the disclosure committee, because there were criminal lawyers that serve a lot of population in jail who typically don't have income. You had a woman testify here, Cynthia Chandler, who only represents prisoners. She doesn't have any income, yet she's serving the fundamental rights of every American citizen in prison and those accused of crimes. So if you mandate insurance to criminal lawyers, who are the very lawyers I think we had to pick whose rights were being protected, I think they protect very basic rights of all American citizens. If you mandate it for them, I have been told by many of those lawyers, and you can actually poll CACGA, which is the criminal bar, they would stop practicing law. They would leave the state. They would not protect the very people whose rights the Constitution is meant for. I mean, so that access to justice will be denied if you require criminal lawyers to be insured.
That obviously is a big issue. So just definitionally, going back to the two different thoughts on access of justice you identified, I don't think the access of justice issue is that we've got victims of legal malpractice that are not being paid. To me, that's not access, the impact on access to justice. Access to justice is, as you just described, that is we're gonna put a load on those lawyers that are performing a public service in many ways because of the devotion to that clientele and the devotion to those issues.
Yep.
And if we pile on top of that a charge for legal malpractice insurance, whether it's in the open market or as part of a captive program, that's going to impact it. And we've heard a lot about that over the course of our last meetings. And so I leave that out there for everybody to consider whether that's enough of a correlation for you to say that may not, that is a detrimental impact of a mandatory insurance program. On the other hand, you could look at that and say that's just something that needs to be sort of assumed in the marketplace, and over time it'll sort of balance out. And the impact to clients that have public interest issues or access to justice at a low rate or no rate basis, will they be permanently impacted, or will the market find a way that makes that work? So,
Yeah, I have a few quick comments. In terms of the criminal law lawyers, there's no reason why if a program, a mandatory program is set up and we exclude government workers and in-house counsel, there's no reason why we cannot make a special class of lawyers who do criminal law, and they can pay, a piddling amount of insurance, and because of the recognition that their clients can only prevail if the client can prove that they were factually innocent. So we can't have a policy, or we're never going to be able to get a policy if we have small number of exceptions. And we say, well, we can't have our policy because we have, 1% or 2% of the lawyers over here that the policy doesn't work for. We cannot allow the exceptions to swallow the rule. And the same is true. I remember one of the presentations, I can't remember who it was, but who was talking about the low bono practitioners, and that they had built this organization together, and in order to actually start representing the clients, they had to buy into the policy that the low bono organization was able to procure. Again, there's a way to deal with the exceptions without throwing the baby out with the bathwater. And if we're talking about having a premium that's going to be $2,000 a year or $2,400 a year, and somebody's working $1,000 an hour, they're going to have to raise their fee by $2.40 per hour, and they've made their monthly nut to cover the extra money of the fee. And again, I think our main consideration is to protect the public and not the lawyers. And let's deal with a rule and then deal with the exceptions and try to figure those out.
Okay. And we've heard from other programs on exceptions or subsidies, or however they described it, with certain sorts of practices. We've talked a lot about that here, so I think that's another big area to consider as to whether that impact can be mitigated somehow by special rating policy or policy that gets a 50% discount or something like that. So, yeah.
Yeah, I'd also, the access to justice seems to me a completely separate issue, that there may be an impact, but it's a separate issue that's much broader than just what effect mandatory insurance might have. And I also think it's important to think who pays for access to justice. Should it be people who suffer malpractice and have no compensation? They're the ones who are paying for access to justice? Or do we as society have an obligation? And I would say we've got to do a hell of a lot more for access to justice. But it seems to me that cost should be borne by us as a profession, by us as a society, and not necessarily say, well, we'll stick these few people with the cost, if that in fact is true. And I want to say I agree with the access to justice, but I just don't find it persuasive to say, so let's keep the cost for some access to justice on people who are suffering malpractice without compensation. And I don't have an ultimate opinion on where I'm going to come out on all this, but I just wanted to note that that argument was not particularly persuasive to me.
If I could weigh in on that, while I understand what you're saying, we don't have any data that says who those people are, how many of those people are that are suffering because there's no malpractice insurance. We don't know what that impact is because, again, we're missing data. And that just is another hole we need to fill. I think we're making a lot of assumptions. Some assumptions are likely true, but again, we don't have data for a lot of what we're saying. We just know in our gut what we think might be the case, and it makes it hard to come up with a solid policy recommendation based on that.
Okay. But, you know, to be devil's advocate, who cares whether it's one person in the state of California that was not made whole as a victim of legal malpractice, or who cares if it's one lawyer that's not insured? Get everybody insured, and that'll take care of both problems.
Because, again, you could be directly impacting the ability of people to provide services to.
I agree with that. I agree with the idea that the impact on access to justice, where you've got 2 or 3 or 4 organizations represented in this room, where access to justice is a cornerstone of our agenda. So it's an important issue to everybody. We want to make sure that we're not, that the other hand knows what we're doing here when we decide mandatory insurance is a good thing to have, that we're not shooting ourselves. But I want to get this done.
So I just want, so this is kind of almost a non sequitur, but it's part of what we were dealing today. And we started, I guess, and then we kind of went on a tangent about about some of the process and then somebody would commented on takeaways. And so the one thing that I took away from both Canada and Oregon, and Mark mentioned it, but he talked about it in terms of dollars per insured. But I think that both of them talked about the robust risk management and claim repair processes. And I just wonder if there's a way to put something together that would address those issues, or at least that's something part of our recommendations that maybe we should think about, is having something on the state level for that, even regardless of what we're doing. I mean, it can be in conjunction with if we end up saying, yes, we should have mandatory insurance. But if we don't, maybe that's something that we should be thinking about as well. And I don't know that we've addressed it that much, but they talked about it, and I thought maybe that's something that can be carved out of this as well.
Yeah, that's a really interesting idea, because one of the things I thought came out of Carol's presentation is that, you know, they really do have a big incentive to incident report. You know, they have this kind of robust incident reporting, claim repair kind of apparatus that, you know, and maybe there's something there. I don't know how you fashion it, but it's an interesting idea.
Yeah, because who cares? Report your claim, report the incident. It's not going to ever affect your rate, or at least
Right.
marginally it might, but you know, you're all in the same pool unless, you know, everybody reports tons of claims, it's not going to affect it. So yeah, report all day long.
Yeah, well, we've all had that discussion with people where they say, hey, should I report this? And I have never said no.
If you're thinking about it, that means you should report
it. In all my years, I've never said don't report this.
Well, so the access to justice is obviously a great issue to give some more brain power to, and how you perceive the impact on that, or whether we don't have enough information to be able to assess
the other, to me, which has been discussed in this meeting and other meetings, is what about those lawyers that can't get insurance? We need some sort of a backstop, and we need a fair plan for lawyers in California.
Give them Al's number.
And so
Yeah.
yeah. We heard from Al, and it was persuasive, and we've heard from others that they've never had an instance where somebody couldn't get insured. Okay, so you take the 30,000 uninsured lawyers in California and tell them you've got to get insurance, and 29,000 of them, no problem. Maybe 15,000 are criminal lawyers, and they get the inexpensive, efficient LMIT product, and they're not happy, but they've got it. They've got a solution in the marketplace. The hard to insure group, that concerns me because I can see some of them saying, I'm now effectively being told by an insurance company or by the insurance industry that I can't practice law because I can't get insurance. They shouldn't be practicing law if they have that many claims and they're uninsurable. So the process works its way out. All right, so we weed out the undesirable risks out there. It's the same with operating a motor vehicle and having to be insured or they have risks weeded out there because they can't get licensed anymore. I don't know. Those to me are pretty easy. We've got, we are actually at 4 o'clock. Does anybody have any last words that you ask?
No. Oh, those are Mark's. I'll take them with me.
I
Yeah.
always want to make sure we end on time, and we'll end on time today. It was a great discussion. I appreciate everybody's attention. I appreciate you getting here and all the work you've done so far. We've got a little bit more to go, a lot more to go. So hang in there and appreciate the engagement. Thank you.
All right. We'll see you later.
Yeah.
Gee, I think I like Mark's classes. So we're gonna probably should be scheduling a call today. I'm gonna be traveling a lot.
Very few hard. Yeah. Well, we definitely got to do that.
I'm gonna take off for Christmas and New Year's. Before you know it, it's gonna be so much stuff. Definitely schedule it soon. Thanks, Linda. Sure.
You can call Jan Luger, who's a 44 boxes.
Yeah, we talked this week.
They still provide